It is 9 o'clock. Good morning to everybody. Can you hear me in Pecos Hall?
Yes, we hear you.
Awesome. Thank you. My name is Gerasimos Rosados. I am the acting director for the Oil Conservation Division. I'm also the acting chair for the Oil Conservation Commission. Today is May the 21st, 2025. And we are in our continuing hearing of the consolidated cases of Goodnight Midstream and Empire, New Mexico. Before we start, as always, I'll do a roll call. As I stated, my name is Gerasimos Rosados. I am the acting director of the Oil Conservation Division and the acting chair for the Oil Conservation Commission. Last time we started with Mr. Lampkin, so this time we'll start with Dr. Ampoma, if you wouldn't mind introducing yourself.
Good morning. I'm Dr. William Ampoma, Professor Petroleum Engineering at New Mexico Tech, and also the designee of the Energy Secretary. Thank you.
Thank you. Mr. Lampkin.
So I'm sorry to interrupt. My name is Trevor Arnold. I'm the reporter assigned by Veritext. I haven't even had a chance to really set up all my speakers in my software, so I don't know if we're on the record right now. I need to start recording this and having this transcribed. I'm not aware, and there's 33 participants, so I don't even know who's going to be speaking. That's a lot of speakers for my software, so I need to get situated before we get started.
I am so sorry that they did not give you the information. It's a little disconcerting that Veritext has done this to you, so my apologies. You're the second individual that they've done this to this week, so that's a little disconcerting to me, but my name is Gerasimos Rosados. How much time do you need to get yourself up and running?
Well, considering the fact that there are 32 other individuals in this meeting, I need to figure out who's going to be speaking because my software only supports up to 20 speakers. So I need to figure out how to differentiate between that. And also, I can't see the other people talking because there's 4 pages of speakers here. So I'm totally in the dark right here.
Let me interrupt you just 1 second. It's not going to take all 32 people, so you don't have to worry about it. The majority are going to be in the big screen that you see, Pecos Hall. I've made it big screen on mine, but the hearing is happening mostly in Pecos Hall. I will be talking. As I said, Gerasimos Rosados. I believe my name should show up at the bottom, and so you can spell it from there. Our hearing officer is also going to be talking off of the platform. His name is Rip Harwood. I believe he just waved at you.
Hold on. Just because there's 4 pages, I literally did not see anything happen. I don't know how to change the setting on Teams in order to see who's actually speaking at it. Rip Harwood. Okay, I scrolled to the second screen.
Awesome.
You know, and when the person speaks, they will show up on your screen.
So it is not. That's the problem. It was not doing that when you started talking. I didn't know who was talking.
So, Mr. Arnold, let me just finish so I could just tell you, and I think it'll help us. So it'll be myself and Mr. Harwood, and there's a Mr. Suazo on the Teams platform that will be doing any talking. Mr. Suazo, if you wouldn't mind just saying something so he could potentially see you. Is Miguel on Teams today?
I'm on. Good morning, Mr. Arnold. Miguel Suazo with Beatty and Wozniak representing Pilot Water in this proceeding.
There, it popped up that time. Thank you.
Okay, so it'll be the 3 of us mostly off of the platform talking. Everybody else is going to be in Pecos Hall, and what I'm going to do is, because we had this yesterday, at our next break, if you will get with Sheila Apodaca, she will stay on, and she will email you the list of participants that are in Pecos Hall, so then you can get those names as well. As far as pressing record, if you don't mind pressing record now, we would be good.
I was recording whenever you said the time on, and then so I've been recording this entire time. So okay,
excellent.
So it's going to be y'all mainly, and I'll catch up on the other parts.
And you'll catch up on the names on our first break. Sheila will get you that information. Sheila, if you wouldn't mind providing the same information for Mr. Arnold.
I will.
Thank you so much, Mr. Arnold. Any other questions?
No, sir. Thank you so much. That clears everything up.
No problem. Glad to help. Okay, so we have a hearing. We're ready to start. As I always do, I start on the left-hand side of the room and move my way over. Empire.
Corey Waymeyer for Empire. We're ready.
Okay, excellent. Good night.
Good morning, Mr. Chair. Adam Rankin with Holland and Hart on behalf of Goodnight. With me today is my colleague Nathan Jurgensen.
Excellent. Thank you. Rice.
Matt Beck on behalf of Rice Operating Company and Permian Line Service LLC.
Did you notice I did not call you Mr. Rice today, Mr. Beck? I just said Rice.
I did. Thank you.
You're welcome. Thanks for being patient with me on that. And pilot, Mr. Swaza, if you wouldn't mind one more time.
Yes, good morning. Miguel Suazo with Beatty and Wozniak appearing today on behalf of Pilot Water.
Excellent. Thank you. So as I stated, this is the consolidated cases by Goodnight Midstream and Empire, New Mexico. I will just read the case numbers one more time. So it's case numbers 24123, 23614 through 17, case number 23775, and case numbers 24018 through 24020 and 24025. Mr. Harwood, we transfer it all over to you again. Thank you.
Thank you. Good morning, Chairman. And good morning, everyone. So let's see, when we broke yesterday, there was a proposed Empire exhibit that Empire was going to run by the rest of the parties. Did that happen, Mr. Waymeyer?
Yes, we provided that to Mr. Rankin.
Mr. Rankin?
Good morning, Mr. Hearing Officer. Yes, my colleague, Mr. Jurgensen, has reviewed that document and we have no objections to its admission.
All right, Rice, have you had a chance to review? What's your position?
I have no objection.
And Mr. Suazo for pilot.
No objection.
All right, that document will be admitted. That was the only preliminary matter, but it does raise an issue with respect to the parties' exhibits. There are lots of them. Exhibits that were prepared and exchanged before the hearing, and also additional exhibits that were offered during the hearing. So it'll be Miss Apodaca that will be maintaining one set of everybody's exhibits. Basically, she'll be like the court reporter is in a courtroom, and it's going to be the party's responsibility to, at the end of this proceeding, not necessarily today, but at some point in time, get her an updated list of all of your exhibits, and make arrangements with her to go through and make sure that she has copies of everything on your respective list. If you want it in the record, that's going to be your responsibility to make sure that each of everybody's exhibits are there's a copy of them with Ms. Apodaca. All right, and then after closing arguments, remind me, and we'll talk about findings of fact and conclusions of law. But I know you're all probably, as Mr. Waymeyer might put it, itching to get on with your closing arguments. So not sure who's going to be presenting for Empire, but whoever it is, are you ready to proceed?
I'm ready, Mr. Harwood. I'm going to try the technology to share and see if we
I'm
get
sorry,
this.
I need to interrupt real quick. I don't know who's speaking at the moment.
Corey Waymeyer for Empire.
Thank you, sir.
Excellent. I think we have it working, Mr. Harwood. I can proceed at your pleasure.
All right. Please
Mr.
do.
Harwood, Mr. Hearing Officer, give me 1 second. Let me just interrupt. Mr. Arnold, can you see Mr. Waymeyer's name at the bottom of the screen now, since the screen is being shared? Okay.
I can
great.
now. Thank you.
Okay, Mr. Waymeyer, my apologies. Mr. Hearing Officer, my apologies for interrupting.
None needed.
Very good. May I proceed, Mr. Harwood?
Yes, please.
Thank you very much, and may it please the commission. I want to start by saying a sincere thank you on behalf of Empire to the commissioners. We really recognize that this has been a tremendous burden on your resources, on your time, that y'all have spent a lot of time reading and looking at exhibits and formulating questions. This is time you could have spent on other things, could have spent with your classes, could have just spent doing things that are fun. It's incredibly important to the state of New Mexico and to Empire. That's why we're here. I also, on behalf of the entire trial team, want to say a thank you here for Mr. William West. We've got Mr. Jack Wheeler of Empire, Daryl Davis of Empire, Royce Landing. They all also thank you for your time and what you've done here. Additionally, the entire trial team of Ms. Hardy, Mr. Shaheen, and Mr. Padilla. Now, this has gone on for months, and we've heard from a lot of witnesses now. We've seen a lot of exhibits. I just want to breeze through some of what we've seen to just kind of refresh some memories on some of the matters that Empire thinks is really important and dispositive here. What we heard is that the EMSU was formed in 1984, comprises 14,000 acres, 58% of which are owned by the state of New Mexico, 20% by the BLM. And since 2021, that's operated by Empire. Goodnight knew before they came here that EMSU had been properly formed and had been unmolested for nearly 40 entire years. With respect to the unitization agreement, this is not complicated. Goodnight just does not care. What was covered in that unitization agreement was the unitized formation and unitized substances. Unitized substances are defined as all the oil and gas that occur within the unitized formation. The unitized formation is all of the San Andres and all of the Grayburg, all of it. With respect to the rights and obligations that were vested nearly 40 years ago in 1984, now going over 40 years ago, that was the exclusive, that is not sharing with the Dallas-based trash company. That is exclusive right of the parties, including all surface rights that are necessary or convenient to prospect for, produce, store, allocate, distribute unitized substances, are delegated and shall be exercised by unit operator. That is Empire. The reason we are here is that Goodnight disrupted 40 plus years of status quo, coming in and putting trash into a properly unitized interval. Empire relied on Exxon. You've heard from the Goodnight witnesses that Exxon is a world-class operator, largest oil producer in the United States. Exxon identified a ROS in the San Andres, 350 feet thick, going all the way down to 700 feet subsurface with 912 estimated barrels in place. That ignores the entire Grayburg ROS as well. Empire came to this EMSU for the significant CO2 and enhanced oil recovery potential in both the San Andres and the Grayburg, as well as the water flood opportunities in the Grayburg. What did Goodnight do? They got little postage stamp 5-acre surface use agreements from naked surface owners that they say give them the right to come into an established and producing unit and destroy those reserves. What did the OCD find? The OCD, after hearing evidence as part of the Piazza proceeding, has already made the determination here that if that Piazza well was not stopped, what is going to happen here is a violation of the OCD duties to prevent the drowning by water of stratums or part thereof capable of producing oil or gas or both in paying quantities, and to prevent the premature and irregular encroachment of water that would tend to reduce ultimate recovery of crude petroleum. You heard from Mr. McGuire yesterday. He said, I agree. Empire has brought even more evidence to these commissioners than what they brought to the OCD when the OCD has already found that this burden has been met. How did Goodnight even get in here? Through deception and lying to the OCD. And we saw that in the applications. How can this OCC yank these applications and permits? Well, one, if they contain a material mistake. We have seen that in spades. If they made an incorrect statement on which OCD relied, we saw that in the applications in spades, and we heard from Mr. Aleman about that. Or if the injected fluid is escaping from the approved injection interval. absolutely, that is already occurring. It's going to continue to occur. Or if the injection could lead to waste. These are ors. Any one of the four, all four of these are met here. So bases 1 and 2, I'm going to talk about those very briefly. They stated that the proposed SWD will be injecting water into the San Andres Formation, which is a non-productive zone known to be compatible with formation water for the Wolfcamp and Bone Springs. That is utter nonsense. The entire Goodnight case and their actions from the first day they laid a foot onto the EMSU has been utter nonsense. The true statement that they should have put on those applications is that that water is not compatible with the San Andres, and that the San Andres is a known and unitized oil and gas producing zone, not just in the IMSU, but very near the IMSU. Within 2 miles, you can find San Andres producing wells in the Wortham wells and the Midi Weatherly wells. Additionally, in the 658 and 660 well, those have swabbed oil out of the San Andres. Those exhibits are in the record. Basis 3. The injection fluid is escaping the approved injection interval. There is no impermeable barrier. Apparently, an impermeable barrier is a purple cartoon that shows up on a poster board when the poster boards don't even align with themselves. The methodology made no sense. It had no scientific footing or grounding. That wastewater is communicating right now out of the permitted formation up into the Grayburg. And you heard, this is the most concern. If I was the OCC, the thing I would have been most concerned to hear about was when Mr. McGuire said, we haven't even tried to map where our water's going. The water is going into the Grayburg. And in terms of the aerial displacement, radial displacement of that water, Empire has done the work to establish that. But Goodnight, the trash company, has not taken one effort to figure out where is this water going. And we heard something even more concerning from Mr. McGuire, which is that there's maybe 5 to 10% of pay, according to him. And that this is completely pinched out in the San Andreas to the west and it's completely pinched out to the east. Where do you think we got? They are setting you up for another Crane County incident. We do not need NASA and SMU on New Mexico here on the watch of this OCC. Basis 4. Goodnight's wastewater injection is causing waste. It is washing out right now the secondary efforts in the Grayburg as part of the water flood. It is washing out future tertiary development in the Grayburg. It is washing out and reducing future recovery of oil in the San Andres Ross. That is not just the upper San Andres. You heard from Mr. West that Empire and Mr. Milasek does everything big. If this saltwater disposal is just stopped, they are here ready to spend $1 billion of CapEx to make this a great New Mexico success story. But the water has to stop. And you don't have to take Empire's word for it. Witness after witness, even out of Goodnight, told you all about the RAWs in the San Andres. This comes from Dr. Davidson, Mr. Knights, Dr. Lake, Mr. Tomastic. I only have an hour here for my remarks. I'm not going to get to play all of these, but I'm going to give you some of them, and we'll cite these in the papers to come. $5.5 billion of cash flow to the state of New Mexico's 58% royalties. That's $1.1 billion in royalties, $500 million in taxes. And to the BLM, that is 19% of that is about 0.37 billion. No witness had an answer about why on earth should Empire not get a chance to carry this out to the cost-free, risk-free benefit of New Mexico and BLM. Now, the commission's duties. I start with the New Mexico Constitution. It is a constitutional mandate that regulatory agencies and courts and the legislature ensure that they are preserving the precious natural resources of this state, consistent with the use and development of these resources for the maximum benefit of the people. Now, that includes protecting oil, even in instances in which the minerals are not owned by the state of New Mexico. This is double. Not only are these precious natural resources of the state of New Mexico, they are owned by the state of New Mexico. This commission has a duty to prevent and stop waste. Underground waste is operating any well, including SWD well, in a way or manner that reduces or tends to reduce the total quantity of crude petroleum. Empire took its burden of proof here very seriously, and it brought the commission the evidence it needs to make the decision that this is committing waste now. It will commit waste in the future if not stopped immediately. This commission also must protect correlative rights. Correlative right, a simple way of saying correlative rights is if you're the owner of the minerals in place, if you're the unit operator, it just gives you the fair share chance to go in and produce for everybody's benefit the minerals that you purchase through your oil and gas lease and through your unitization agreement. Empire's asking this commission to perform its duty and protect those correlative rights. That is just the fair share to go in pursuant to its ownership rights and produce oil out of its existing oil unit, including under Section 10 of the unitization agreement. The commission also has the duty to prevent the drowning by water of any stratum or part thereof that's capable of producing oil and gas in paying quantities. And to prevent water encroachment. This pertains to no production in paying quantities whatsoever. The commission independently has an obligation to stop and prevent water encroachment that reduces or tends to reduce the ultimate total recovery of crude petroleum or gas or both. That is already happening right this second. You heard out of Mr. Macbeth's sworn testimony that no investor, no operator is going to touch the production of oil and gas through tertiary recovery efforts in the Grayburg or the San Andres until the salt water injection is stopped permanently. Nobody's going to spend a cent until the destruction stops in the first, right this second. Development opportunities are not being pursued for the reason of only one party, and that is Goodnight. The evidence. We heard Goodnight knew of, but failed to disclose the hydrocarbon bearing zones in the San Andres and failed to disclose the EMSU unit. Now, when it's the Ted Williams that comes later in time outside of the unit, we showed the commission where Mr. McGuire says, can you show me where we did it? They showed the EMSU on that. But in permitting the wells in the unit, no, if the OCD staff who is overburdened and working, when they look at that, it was perfectly intentional that Goodnight left off that EMSU on those papers. Goodnight repeatedly testified that XTO received notice. Now, when they were going to the Devonian, they sent it to XTO's correct address, return receipt requested. When they decided to come up into the San Andres, we saw that they sent it to what might be a field office in Midland, Texas, that nobody has ever understood to be associated with XTO in any shape, form, or fashion. They didn't do it return receipt requested. And then when they were asked about hearing, they said, well, we're not required to notify anybody unless they're an affected party and have already protested. They've played games with the permits and they've gotten caught with it here red-handed.
Questions to you to be that the unionization order is the smoking gun, and once good faith discovery of it, that was a game changer. How should the commission view the discovery by the parties of the unionization order?
In terms of the, I think I'm stumbling a little bit over the term, the discovery of the unitization order. We identified it or Goodnight had identified it as they were picking their locations, and then we discussed it. And in looking at the geology, Goodnight preparing the geology. Goodnight had determined that there wouldn't be that the barrier existed, that the injection into the injection interval would not affect the production within the unit.
Just like it's science and engineering work, the theme that we see over and over and over with this company, Goodnight, even at the very jump in the application stage, is this is a company that just does not care. Let's talk about waste. There is waste occurring right this second in the San Andres RAWs and the Grayburg RAWs. Every experienced and educated science and engineering expert that testified in this case agrees there's a RAWs in the San Andres. We are done. That includes Dr. Trentum, Dr. Lindsay, Mr. Meltzer, Mr. Burkett, Mr. Bailey, Mr. McShane, Mr. West, Mr. Knights, Dr. Davidson, Mr. Macbeth, Dr. Lake, Mr. Tomastic. History will watch what we are doing as part of this proceeding right now and the decision that comes out of it. How many qualified engineers and scientists do we need to come in here and swear that there's a ROS in the San Andres for this saltwater injection to stop?
Do you believe there is any ROZ in the San Andres?
I think there might be a ROZ in the San Andreas directly below the base of the Grayberg, but I've not done any studies on that.
I could play these videos for hours in here.
And we've established that the oil saturation is above 20%, as you've plotted here. Is that correct?
Yes.
Then tell the commission why you say that there is no ROZ.
I didn't say there's no ROZ in the upper San Andreas. Again, I may have a little bit of difference of opinion from Trentham and Meltzer.
Empire took its obligation seriously before coming to this commission and taking this commission's time. Empire has not merely proved the presence of ROZ throughout the San Andreas as a matter of a preponderance of the evidence. Empire has proved it here conclusively. And they've done it through a cross-disciplinary and multidisciplinary approach. You heard the petrophysics from Scott Burkhead and Ryan Bailey. Dr. Lindsay and Dr. Trenum on the geology out here, along with Ryan Bailey. The engineering of Steve Meltzer and William West. These are people who worked independently, who are qualified, who relied on reasonable data and information that would be consistent with their particular expertises and disciplines, who applied sound methodologies that are recognized in actual literature and education associated with their expertises, who came to reasonable and rational conclusions where there is a clean nexus between their qualifications, the data they looked at, the scientific and engineering methods they used, and the conclusions they arrived at. What on earth did Goodnight bring you here? They have yet to bring a geologist into this room to take the oath, to testify to where in the heck the tops are of the different formations we're even talking about. They had engineers that performed the geology in Dr. Knight. You had Mr. Knights, who is the geologist, but didn't do any geology. It's crazy. And with respect to the cartooning, the purple cartooning, I would ask the commissioners to go back. We've heard that they're out of the Goodnight witnesses that there's a ROS in the upper San Andreas. Where in the purple cartoons is there a barrier between the upper San Andreas and the lower San Andreas? None whatsoever. Now, over here, this is what Mr. Knight swore to. Mr. Knight swore, this is at page 2 of his report, the subsequent unitization and operation of the EMSU involved the combined geologic, engineering, and operational expertise of world-class major oil companies such as Conoco, Exxon, and Gulf Oil. Yet none of them concluded that there was any reasonable economic potential below minus 350 subsea. That's just false. And the Exxon sales brochure over here on the left, they've got ROS going down to a minimum of 700 foot subsea. But the point here is that Mr. Knights swore to what is common sense. If there was anybody that had the human resources, the financial resources, the resources to proprietary data, science information, engineering information, it would be these companies of Chevron and Exxon and Gulf and Empire who have had decades of experience precisely in this EMSU. Before knowing we were ever going to have these seats here today for you all to have to make your decision, Exxon independently came to the conclusion that there were 912 million barrels of oil recoverable out of that San Andreas ROS. Now, rock facies. I want to talk a little bit about the importance of rock facies. Now, Dr. Davidson chose a facies model but didn't describe the core and didn't look at the core to even understand what in the heck are the rocks that are subsurface. And I asked Mr. Knights, what rocks is Dr. Davidson even using? And he said, look, we work at Netherland Sewell. I've gone down the hall. I've tried to ask him what rocks he's using. I can't, even after visiting with Dr. Davidson, I don't know what rocks he's using. What we know and can take confidence in is that they're the wrong rocks. We've heard consistently from all of the witnesses except Dr. Davidson that this is a shallow water depositional environment, not a deep water. By him choosing deep water, it placed all of his rock facies into territory where you could never put enough oil into it to get past that 20% threshold for him to give it credit in any of the models. Now, on the other side of that, we brought you Mr. Burkhead as an example and Mr. Bailey, who did actually examine the core, examine the core reports, and include that into their analysis. The corrected oil saturations for Grayberg that Mr. Burkhead calculated, the corrected in Grayberg is 23.94%, about 24% saturation. And in the San Andreas, about 21% saturation corrected. Now, you heard Mr. Burkhead explain that in his opinion, using N values between 11 and 100, which is where Dr. Davidson ends up at, is completely crazy. You cannot use that. You know that that data is wrong, that those N values are way too high. If you exclude the suspicious data, which Mr. Burkhead did on the basis of sound scientific principles, you end up with 25.7% corrected core oil saturation in the Grayberg and 29% corrected oil saturation in the San Andreas off of core. Now, Mr. Knights agrees that if you make the wrong rock pick, you're already into the territory where you can, just by picking the deep water rock, you can never get enough oil in there for this to get credit in the model. So it really gets this simple if you're looking at this from the Netherland Sewell approach. Dr. Davidson makes his facies picks for the majority of the lower San Andreas. Mm-hmm. And based on those facies picks, you have to start with 80% water or even more water. And based on that facies pick, you can not put enough oil in to get past the 20% threshold for your model to give that oil any credit for oil in place.
Correct.
They set up a methodology that could only lead to one result, that being the result that Goodnight wanted and needed because it had already put the pipe in the ground. None of the Goodnight work has been about following the data and the science to the logical conclusion. All of the work has been about reverse engineering to a predetermined result where you get to keep the pipe in the ground. Dr. Davidson agrees his rock facies pick can be off. What I'm coming back to is you would at least give me that with this paucity of data, it's possible that you would be off by one rock facies. For example, what you classify as mud-dominated packstone could be a grain-dominated packstone. True?
Suppose it's possible.
And again, he understood, the non-geologist thought this was a deep water environment, which contradicts every other piece of evidence that's come out. This is the combined work of both NewTek and Ops Geologic. And you can see there where, and I'm looking at the 628 well specifically, Ops Geologic has their, what they've calculated through Mr. Burkhead's petrophysical work is 28 to 47% oil saturations in the 628 well. In the 660 well, it's 14% to 28% oil saturations that have been calculated. And in the 746, 41% to 69% oil calculations that have been calculated. Why on earth would Empire, who spent tens of millions of dollars to buy these oil and gas leases, not get the opportunity to prove Mr. Burkhead right? For the part of Goodnight, this is the science work they brought us. Even after examining Mr. McGuire for our, I have no idea what this is, and we asked him, have you ever seen the OCD permit wells and approve applications based on water management barriers and a water management zone. Just help me. Where in the OCD file do I find this so that we can have an intelligent conversation with the commissioners about how this fits into anything? He had nothing. The question is whether in the San Andreas, there is an ROZ, and in the Grayburg, is there an ROZ, and is there communication? If Empire has met a preponderance burden on any one of those three things, we are done here. It gets to proceed with its development, and the saltwater trash injection gets stopped. But again, off of Mr. McGuire's work, all of the green that's down in his water management zone, that is oil. And to be more precise, 58% of that is the state of New Mexico's oil. And you don't have to take Empire's word for it. Let's take Dr. Davidson's word for these oil saturations all the way to the bottom.
Again, I'm not going to get into the pick argument. It's just that just happens to be where this San Andreas is. If you go down, you'll see in the oil saturation track, periodically I do calculate relatively high saturations. I mean, there's some up to 30 and 40% in there. They show up periodically up and down the system. So yes, there is oil down in there. They tend to be associated with some of the lower gamma ray readings, and that makes sense because the lower gamma ray readings down there in that yellow San Andreas interval correspond to the grainstones and the better rock types. So yes, there are grainstones and better quality rock types all the way through the San Andreas.
When people are we're reading about transcripts that happened 40 years ago as part of the EMSU. When folks are reading these transcripts 40 years from now, you didn't have to take Empire's word for it. Dr. Davidson told you that 58% of the state of New Mexico's oil is down in the zones, that Goodnight is flooding right this second. Barriers. The idea of that a barrier somehow protects this. Complete nonsense. It relies entirely on mud losses. There's no authority. We've asked, give me the literature. What professor, what scientist has written that you would say mud losses equates to an impermeable barrier? Nothing, zilch. The mud losses are inconsistent. The way you explain the mud losses is by high permeability zones. Just like Mr. McGuire screwed up and said, oh, well, the reason the acid's going here is because it's a high permeability streak. To the extent they've had these inconsistent mud losses at inconsistent depths and inconsistent volumes, that's explained by the high permeability rock that's in the formation. They wouldn't know about that though, because not one single Goodnight witness has ever looked at the core. Goodnight concedes there's no evidence or literature showing a barrier goes all the way across the EMSU. To Mr. Lampkin's questions, you're showing us this little part. If we're to believe that this is a beautiful and perfect barrier blanket across 14,000 acres, where's that mapping? If you get outside of his little area of review, he's told you nothing about what happens north, and he's told you nothing about what happens south in the EMSU, let alone anywhere adjoining the EMSU, knowing that we have San Andreas production within 2 miles of EMSU right now. They failed to understand. This is probably, if I took one thing that Mr. West just cannot sleep at night, the idea that Goodnight is still in here with Mr. McGuire swearing that the pressure is higher in the Grayburg than the San Andreas is just mind-boggling. They rely on that faulty assumption. And in his rebuttal sworn testimony, you can see on the data that they want, even though they know it's completely false, but that they cling to. If you read Mr. West's rebuttal sworn statement, he explains exactly the problem with the algorithm and the measurement and why those readings are there. It's also not supported by core. This OCC is to take the word of Goodnight about barriers, which they've not mapped across the EMSU. This is what you would have to be biting off with by way of credibility. No one from Goodnight knows where the bottom of the Grayburg is. No one knows where the top of the San Andreas is. No one knows where the upper San Andreas is. No one knows where the Lovington Sand is. No one knows where the lower San Andreas is. Every expert in here that Mr. Rankin told you on the very first day of opening arguments, I cannot wait to get my experts in here for you to be impressed by these guys. Every single one of them told you they relied on Preston McGuire for their tops. What did Preston McGuire tell you yesterday? He said he didn't pick any tops. How on earth do you caused millions of dollars of harm and caused millions of dollars of attorney's fees and all of y'all's wasted time in this proceeding, and you haven't brought a single geologist in here to swear to the tops and the methodology associated with picking up. Nobody from the part of Goodnight looked at or described the 679 or RO Bell course. No one has, before Goodnight, has ever called 7% porosity an impermeable barrier. Where in literature, if it's something other than the commissioner should take your word for it, where do we find it? Goose egg, nothing. No one mapped the entire EMSU. No one prepared a material balance simulation or model. It's easy to rip at and tear out and claw at and criticize and poke and slander the work of Dr. Buckwalter. If Goodnight had any earnest belief in the science of their position, they should have built their own material balance simulation and brought it in here to the commissioners and explained Dr. Buckwalter's wrong. They didn't do it because they can't do it. This is the geology work of Mr. McGuire. He literally came in here and swore to this commission that there's a confining layer in tens of feet in which he didn't even have core because it was so cracked up they couldn't get it up in the hole. I was the one who showed him for the very first time photos of the actual core that he's calling confining layer. And we went through those and we zoomed in on them. And you could just see with the naked eye how cracked up this rock is that he calls confining layer. He didn't, before he chose confining layer, he didn't know that because he didn't examine the core, even though it was available to check out from the BEG. And he didn't look at the photos, even though those were also available. We went through the actual core laboratories report. And again, the one he chose to show y'all at 4335 had a vertical, we're not talking porosity, it's a vertical permeability of 10 is what Preston McGuire brought you in here as his great example case of impermeable barrier confining layer. I can tell you Empire's terrified of the work that this SWD disposal trash company is doing in its unit. I think the commission hearing about Goodnight operating in other places in New Mexico should be equally terrified. Dr. Lindsay, he prepared an actual fracture study, the work that a geologist would do in an important case such as this one. Goodnight did not bring you one single fracture study. The cartoons, I mean, we showed these things were wrong every which way, but I mean, the idea that this would be prepared off of 7 porosity, just eyeballing paper raster logs, and that you would come in here and swear to this commission that this is a barrier. He agreed that some of the purple is going to have higher than 7% porosity. He agreed that somebody in their group actually liked the purple rock so much they chose to put perfs into it. We showed you instances in which the exact same well, they had literally cartooned the exact same well, and the alleged barriers, the purple cartooning doesn't match up in the exact same well. None of it correlates across. And the importance of these open hole completions and putting all these perfs, if you indulged, if you just believed that every single one of the purples was a barrier, as soon as you poke that top hole, or as soon as that water gets to the open hole completions on the older wells, where does it get? It's going to go straight up to the Grayberg. And this is what I didn't spend any time with Mr. McGuire on this, but as I talk about the OCC should be terrified that Goodnight has been turned loose on the state of New Mexico, here's my cleanest example of that one. If you look at this Snyder well right here in the middle, the blue is what they permitted with the OCD. Right today, if they want to put perfs right there, they told the OCD in getting that permit that that was perfectly fine and would be appropriate. They literally told the OCD that all the way up to that would be a fine place for saltwater injection. There's no barrier above that. This is the cleanest example of them straight lying to the OCD. If their work really showed that is barrier, then why on earth would you have told the OCD that you could inject at the very top of that? Makes no sense whatsoever. And on the green, one of the commissioners asked the question, we've talked about the different zones. If we're to believe your barrier work, this cartooning, where are the different zones reflected within the Grayberg? Why do we have places where there's no log whatsoever, but you've cartooned down here? How can you cartoon miles between wells when the log that you're using, that tool goes 3 to 5 feet into the rock. It makes no sense whatsoever. It's all because this has always been a case about trying to reverse engineer a result that lets them keep their pipe in the ground, not what science and engineering would actually lead one to. Empire presented conclusive evidence of communication. This is the 1989 Chevron paper, the 1996 Chevron paper. Over in Mr. Love's paper from Chevron, talks about the bottom water coming up. I asked Mr. McGuire, where would bottom water come from? Before he knew this is where I was going with it, he said, well, it's going to come from the formation below. But then when I show him the actual paper that he cited and relied on, then he said, well, the bottom water might come from the edge, which I'm a lawyer, not a geologist or an engineer. I would call that edge water, not bottom water. He wanted to point you in Dr. Lindsay, a man who has spent decades of his life employed by operators in the EMSU, who prepared an over 1,000-page PhD dissertation on this area. He wants to tell you what Dr. Lindsay thinks and what he's come to a conclusion of. And he highlighted you the orange. We showed over in the yellow where Dr. Lindsay, before knowing he was ever going to be an expert in this case, specifically identified vertically oriented plumes of upper San Andreas Formation water within the Grayburg Formation. Dr. Lindsay did not know that he was going to come testify to this OCC in February. He did this independently years before knowing any of this would happen. I think this slide probably tells the story the best. So many witnesses were asked, how do you explain this pressure depletion, but for communication with that lower pressure Grayburg Reservoir above?
Those blue showing the pressure.
Yeah.
So you are attributing, when you look at this, you are interpreting this one.
I do see. Yeah, it could be the production. Yeah.
So if it could be, did you include that in your analysis, in your conclusion, to say that it is due to a barrier?
No, did not.
So that could be an uncertainty in your analysis then?
It could.
Thank you.
We also, we've spent some time with this bubble map. The Goat Seep Aquifer Drive to the southwest, the testimony has been universal that would be a very weak water contribution here, if any. And in fact, you heard that from Mr. White. Mr. White, this was the one where he's got it flipped, where you've got T1 and T1 prime, and the west is actually over on the right. What Mr. White testified to here very credibly is that as you move, these are flipped around in my head now. As you move from the west, that rock gets tighter and tighter, and that Goat Seep is pinched out before you even get to EMSU with very little contribution there. Dr. Buckwalter's model, again, only 99 grid blocks out of 34,500 had to have vertical permeabilities adjusted. All of those vertical permeabilities were adjusted within ranges that were identified in core and reasonable off of core. Dr. Buckwalter's work is sound. They can always fuss at it. As Dr. Buckwalter said, you can always say you could have done more, you could have done a better model, you could have done this, you could have done that. But the model is sound, and if Goodnight thought it was not, they should have brought their own, and they did not. Dr. Davidson agrees it's reasonable to assume that there's fractures causing
I'm asking you, very simple question. Is it typical in the oil and gas industry that with the knowledge of fractures from a core, and then also with the cast that you've even added to it, it is reasonable for a reservoir engineer to assume that there could be a localized either cast or fracture causing this high water production?
And I would agree with that. It's a reasonable assumption. Where I differ from Dr. Buckwalter is that I think that water could be edge water coming in through karsted system through a tortuous pathway from the edge.
Dr. Lake also agrees.
Now, don't you believe that that more or less aligns with Empire's assertion that there could be a potential communication, especially now you're talking about these casts and then the fractures, could be a potential conduit for fluid movement?
It could be.
So
Water chemistry. I'm not going to dwell on water. I thought we were going to have a chemistry discussion because we saw so much of it in the sworn statement from Mr. McGuire, but it turns out he's not an expert. We actually heard that it's 250,000 TDS is the water coming from the Delaware. And through, he doesn't know how, but they get it down to 120 to 150,000 TDS before sticking it into the state of New Mexico's minerals, the state of New Mexico's pore space, and to Empire's unit. And we've heard that there's high sulfates in the water in the upper San Andreas. And you heard from Mr. West and others about all of the bad things that happen when you're mixing the strontium, the high TDS, the chlorides with the sulfates. And because this is an existing water flood that was approved in 1986, 84 to 86. If you put one drop, you take one drop out of the San Andreas to use for makeup water as part of the water flood in the Grayburg, which is happening today, it touches every single well bore. What happens? Well, we saw it here in the Rhino well. Within 6 years, they had to conduct a $650,000 workover. The entire Christmas tree had to be jumped because of corrosion. They replaced two different strings of coated tubing. The casing itself in the top 100 feet was scaled up and corroded. This is an example of what is going to happen to hundreds of Empire's Grayburg wells that it is lawfully producing right now as part of the unit agreement. And again, this is going to be oil lost. This is going to be millions of extra dollars spent when what starts happening and continues happening to Empire's wells, we saw right here within 6 years of a brand new well out of Goodnight. We don't have to prove economics, but we've done it anyway. With respect to application of production paying quantities, Mr. McBeth confirmed on the record, you do not consider capital expenditures. PPQ, production paying quantities, is merely an exercise of recurrent revenue over recurrent expense. Is it profitable or not? You exclude all the CapEx, such as drill and complete costs. If you take that out here, take out CapEx, every single human in this entire room agrees this is a profitable undertaking down in the San Andreas. Mr. McGuire swore about PPQ over here on the left, but when he was asked in his deposition about PPQ, he says, yeah, actually, I have no clue how to do it. Mr. Rankin put that in my witness statement. Mr. McBeth, here, I always like to make things as easy as I can for whoever's the fact finder. If this commission just accepts, you can use all of the Davidson and Knight's volumes. Use Goodnight's volumes. But just agree that $75 WTI with a modest 1% escalator is right, and that $CO2 with the 45Q is reasonable. Mr. McBeth tells you, again, this is taking your volumes. As we talk about why on earth wouldn't Empire get an opportunity to develop its and the state of New Mexico's minerals using your volumes, if a 1% escalation off of $75 WTI is applied and a $1 CO2 price, you can tell the commissioners that that is a positive net present value case, isn't it?
That one looks like it calculates out slightly positive.
Mr. McBeth tells you the biggest driver on getting all of this oil that Dr. Davidson swore is present to the bottom of the San Andreas is just the price of oil. We brought you this 4-county appraisal in the San Andreas. This is a ROZ, ROZ public. They were assuming for their model $75 oil with a 2.3% escalator. EIA data, I can go on and on and on about escalators that are more aggressive than the modest 1% that Empire chose to apply here. Now, I found one thing we agree with Mr. McGuire on. It took a deposition, a bunch of sworn statements, and 2 days in the stand. We found one thing that Empire agrees with him. He said, justice delayed is justice denied. That's a quote from Preston McGuire on May 20th, 2024. We could not agree more. We need this commission to act now. Every day that goes by is more harm. The graphs show it all. Look at these volumes. All of the blue volumes, those are others. You heard them testify in terms of what Empire has ever injected or its predecessor. It's less than that a little gray line. There is a trend here beginning in January of 2020, and the trend is not good. And the trend only results in the continued and total destruction of the state of New Mexico's minerals. You've heard Mr. McGuire say, as you suck out, the pressure plummeted. It's in his sworn statements all over the place. When the water supply well started and it was taken out of the San Andreas, pressure plummeted. Well, then how on earth, if you put the water back, does the pressure not shoot back up? He had zero answer for that, but there is a trend here. This is no different than the Crane County trend by Goodnight. Every 2 years, they're doubling what they're putting in to these formations. It's already destroying. It will utterly and unfixably destroy these reserves. I did not know in his redirect, he was going to say there's a plug in the well. We've got the entire workover report is now been admitted in evidence. Y'all will have that opportunity to take a look back at. There's no plug. He said there was a plug set in the Rhino well. That's completely false. They didn't calibrate their fluid gun by taking into consideration the pup joints. If you actually counted those collars, 22 collars, if you use the average of the longest joint of pipe, you get down to within 2 feet of the number that they've got on their chart here on the right. If you use the wire line measurement, you were dead on if you actually account for the pup joints. The area of influence, it's just going to get worse and worse and worse. And we know that they fussed. Why hasn't Empire started? John Macbeth will tell you, no one's going to spend 50 cents of capital in this EMSU until they are stopped. Wouldn't they want to also know if a commercial saltwater disposal operator is injecting hundreds of thousands of barrels of saltwater into the recovery unit?
If the injection is taking place in a zone that you're going to try to do a CO2 flood in, that's right.
Okay, so that the commissioners, as they make their decisions in this case and talking about what an investor would want to know about before starting a tertiary project here in the San Andreas, you with me so far on what we're talking about?
Yes.
You can tell them that an investor would absolutely be aware of and concerned about saltwater injection into the EOR tertiary flood area. Yes.
Yes, as long as we're on the same page, as long as that hypothetical CO2 flood is in the zone where the saltwater is being disposed of.
And again, it has to be permanently stopped. These are 40-year life projects involving $1 billion of capital expenditure. Nobody's going to spend $1 billion in capital, or 50 cents for that matter, if the result of this OCC decision is that Goodnight is merely paused for 5 years or 6 years or 7 years, or that they only get to make a little bit of waste. We'll just let them make this much waste. The project cannot be carried out unless all waste injection is stopped, and if it's stopped permanently, so that 40 years of planning can be properly carried out. And Mr. Macbeth wasn't asked in terms of any kind of relativity or volume. It was just the idea of somebody going in to conduct a tertiary project with any volume of commercial SWD in that zone.
Fourth floor.
So in terms of requested relief, what's Empire asking this commission to do? Empire is asking the commission to fulfill its mission and protect New Mexico's minerals, protect the BLM's minerals, protect OCD's established oil units. You heard Mr. McGuire say they took the permit, the slightly earlier permit, as permission. Hey, state of New Mexico OCD, they're permitting SWDs and oil units now. We want to get up out of the Devonian. We want a piece of this San Andreas too, since the precedent has been set for permitting in existing oil units. That precedent should not be, that is erroneous. It wouldn't have happened had they been truthful on their applications. It should certainly not be perpetuated. This is the chance to stop it right here. And we asked that this commission protect Empire's hydrocarbons in the entire EMSU unit, exactly like paragraph 10 of the unitization agreement gave them the exclusive right, not a little bit of the right, not most of the right, exclusive. No trash companies in their depths. The commission can do that by immediately stopping the injection and denying the permits for more injection. This is the only, again, there's no halfway in this. There's no split the baby. There's no let's do it a little bit. This is the only resolution that avoids waste and protects correlative rights. I have 10 minutes held back that I'm going to get to react and wrap this up after Mr. Rankin finishes. Again, thank you so much for your time and your attention. I look forward to visiting and closing this out.
Thank you, Mr. Waymeyer. Mr. Rankin.
Mr. Hearing Officer, unanticipated, but I'm going to ask just for a short break so we can use facilities.
Sure. All right. Let's take 15 minutes.
Thank you.
I kept laughing every night at the picture. Yes, that's
Hi, Trevor.
Yes.
Hi, this is Sheila. I sent you a couple of emails with information. Have you received those?
I had. I was afraid you didn't have my email address.
Yeah, and it's a lot of stuff. I didn't expect you to be able to read it during the hearing, but
Oh, it's got a whole ton of information. All right. Gone through it, all the representation. Perfect.
and I've given you my phone number, so if you have any questions, you can call me after the hearing or you can text me during.
All right. And right quickly, I'm just going to take a picture of all attendees just so I can list everybody. And what's Mr. Rankin's first name? I never quite caught it.
Adam.
Adam, thank you. And we're going to have, looks like, Mr. Jurgensen next.
Yes.
Got it. Thank you.
And then I'm also videotaping, so I can send you a link to the video on our YouTube channel also.
Oh, that'd be perfect having another backup, basically. That's
Yeah.
perfect. I normally don't have proceedings with this many people in it.
Yeah, most are observers. Not everybody is participating in the hearing.
And then my only other thing is maybe at the end, I may have just a couple little clarifying things just on terms I'm not as familiar with, but I'm seeing a lot of it on the screen, but I'll have a
Right.
few.
Yeah, absolutely. You have my phone now and my email, so just feel free to reach out and I can answer your questions.
I think a good plan of attack is when we adjourn, I'll go ahead and just give you a call right then, and then I can search through my software, make it really quick, and we can knock it out really quick in a phone call afterwards.
That sounds good.
Thank you.
Okay, thank you.
We just about ready to get going.
We're waiting on Mr. Rankin. Here he comes. Okay. Mr. Rankin, are you ready to proceed?
Thank you, Mr. Hearing Officer. I am.
All right, Mr. Court Reporter, you let us know when we're back on the record, please.
We are back on the record. The time is 10:15 a.m. New Mexico time.
Okay, and just for your information, this is Adam Rankin who will be speaking. Mr. Rankin, please proceed.
Thank you, Mr. Hearing Officer, Commission Chair, Rosados, Commission members, Dr. Ampoma, and Mr. Lampkin. I just want to reiterate Mr. Waymar's appreciation for the attention and consideration that the Commission and each of you have given to this case, and that I know you will give going forward as you review the evidence and prepare an order. In Mr. Waymar's closing, you heard a lot of what I would characterize as personal attacks, character attacks, and attacks on the company of Goodnight and its people, its experts, and the testimony they provided. And only vague and cherry-picked references to the data, evidence, and testimony. In fact, one of the clips that you were presented was of Mr. Macbeth. Mr. Waymar was telling you that he was saying that no operator would proceed with development, when in fact what he was just saying was they would be concerned and want to know about it. He showed you a clip from the four-county study about the price escalators to show that it was a higher price escalator than even what they were using. But if you noticed, there was a CO2 price escalator that they used in that study of 2.3%, which Empire didn't use. So there's a lot of cherry picking throughout this case, and especially during closing. And rather than focus on character attacks, I'm going to focus more on the evidence. Now, after weeks of oral testimony and cross-examination and hundreds of pages of written testimony and exhibits, we're at the point now where the Commission will make a decision that could substantially alter the future of New Mexico oil and gas production in the Delaware Basin and the state's ability to safely and sustainably manage the disposition of its produced water, for good or ill. The capacity for produced water disposal in the state's portion of the Delaware Basin itself is now constrained, and that's common knowledge to everyone in the industry. So there's a lot at stake with a substantial and growing demand for produced water disposal in southeastern New Mexico, necessary to support continued oil and gas development in the state. Now, there are growing concerns about the potential for induced seismicity in the deeper Delaware Basin formations, and much of New Mexico's produced water is now being shipped to Texas for disposal because of those constraints. And that's also a concern because there's increasing disposal-related seismicity in Texas. And I can tell you that some of New Mexico's largest producers are closely tracking this case to see whether the Commission will confirm the availability of the San Andres in this area going forward as a world-class produced water management resource, because that's what this is. It's a world-class resource. To date, nothing else like it has been identified in New Mexico. The division confirms two things in its testimony submitted to the Commission: the long use of the San Andres for disposal in this area, and specifically calls out its capacity and, quote, unique quality for accepting injected water under vacuum, making it a preferred opportunity for expanded capacity to satisfy the growing volume of produced water that requires disposal. The unique quality of the San Andres is at least one of the reasons the division became involved in this case. And that's why the division wanted a monitoring program to ensure that the San Andres disposal is not impacting the Capitan Reef, so the San Andres can continue to be used for disposal. The Oil Conservation Division is right to want to protect it. Once the division and Goodnight reached agreement on monitoring, the division was satisfied that EPA's obligations or requirements were being addressed and no longer needed to request that relief from the Commission. Another reason for the division's involvement was concern over adverse actions against previously issued division injection permits. Recognizing the far-reaching consequences of an adverse action against existing injection permits, the division highlighted the importance of taking such a drastic step only with an abundance of caution.
Mr. Arwood, we have an objection to both of the last two slides. None of this testimony has been, these closing remarks are to be directed at gathering up the actual evidence admitted. None of these witness statements were admitted into evidence, and the witnesses were never presented for cross-examination. So with respect to Mr. Powell and Mr. Getz, these are not in evidence, and it's absolutely improper to monologue about them.
Mr. Rankin, I was assuming that these were quotes from or at least I don't, Powell's not a name I'm familiar with. I was assuming that your previous quote from Mr. Getz was part of his written testimony. Is that not the case?
That is the case.
But
Okay.
Mr. Harwood, that written testimony was never offered or received, and the witness never appeared for cross-examination. It is not in the actual record.
Well, I thought it was in the actual record if it's written testimony that was submitted by OCD in this case. I'm more concerned about this quote from Powell.
If I may have an opportunity to respond, Mr. Hearing Officer, both quotes are from witnesses that were submitted, written testimony that was submitted of record with the commission starting in August. I'm just going to respond to Mr. Waymire also presented slides and information that were not accepted into the record, including, for example, the demonstrative that he had Mr. Macbeth speak to. He specifically asked for that demonstrative to be admitted to the record, appended to the record. It was denied. Nevertheless, he presented that on his closing, and I didn't object to that. This is argument of counsel, and the commission members can take it for what it's worth.
May I reply very briefly?
No, Mr. Waymire, I'm going to give Mr. Rankin, a fair amount of latitude and leeway here. It is closing argument, but Mr. Rankin, you do need to really pretty much confine the argument to evidence that's been presented. This is not a time to bring up new information and stuff that's not already of record in the case.
And just Mr. Harwood, for the due process record of Empire here, again, these witness statements, the last two, Mr. Powell and Mr. Getz, have never been received and admitted into evidence in this case. They were filed as part of the preliminary papers. But just as we've done with every witness when they appear, it does not become evidence in this OCC proceeding until it's actually received. And neither of these have been received, have been admitted. They are in no shape, form, or fashion evidence in this proceeding.
All right, Mr. Rankin, that's a fair objection. I hate to have people's closing arguments interrupted, but if these statements are not in evidence and you continue to do this, you're going to get continuing objections, and I'll start sustaining them.
Understood, Mr. Hearing Officer. I have no further references to any of the division's testimony that they filed in August.
Okay, and so your objection, Mr. Waymire, is duly noted. Please proceed.
We agree. For the commission to make an adverse ruling against Goodnight's existing injection, direct evidence needs to clearly support it. There can't just be a potential for an ROZ or an indication of negative impacts. The evidence should be clear and direct. The commission now has an abundance of evidence, and the evidence, especially the direct evidence, as opposed to inferred or interpreted evidence, and opinion or the arguments of counsel, overwhelmingly supports Goodnight's position. Let's walk through it. I'm going to address the evidence that we have establishing the creation of the EMSU first. Before anything else, before the EMSU was formed in 1984, the San Andres in this area was used as a water disposal zone, starting in at least the 1950s. That's undisputed. When the EMSU was created in 1984, the San Andres was included in the unitized interval, and the EMSU was formed around existing commercial produced water disposal that was part of Rice's existing EME disposal wells that had already been injecting into the San Andres. That also is undisputed. The San Andres was erroneously and illegally included in the unitized interval of the EMSU, not because it was productive of hydrocarbons, as is required, or as it had been reasonably defined by primary production, as it also is required, but because it was the only water source sufficient to supply the proposed water flood. The San Andres was used as a water supply source for the Grayburg water flood, even though it was known at the time that it was not compatible with Grayburg water. There's no dispute over that. And at the time the EMSU was created in 1984, the San Andres had no primary production. So it was not reasonably defined by development and couldn't have been and shouldn't have been included in the unit interval. That also is undisputed. The only oil test in the San Andres, in Goodnight's defined San Andres in the disposal zone in the EMSU, was from 2005, decades after unitization. That's from the EMSU 660 well at the very top of the structure, and it resulted in 7 barrels of oil and more than 4,000 barrels on a pump test. Finally, we know the San Andres is an aquifer because it was declared by the state engineer to be subject to permitting requirements for beneficial use in 1965. And every one of the 6 water supply wells in the EMSU was permitted by the state engineer for water withdrawal. That means that Gulf Oil's original application to unitize the EMSU, claiming the San Andres was reasonably defined by development, was incorrect. The whole premise for its inclusion in the unit is invalid. Under the Statutory Unitization Act, the Commission has authority to unitize only pools or portions of pools that are reasonably defined by development. That wasn't the case for the San Andres. It still isn't. And the Commission has no authority to unitize an aquifer that was not defined by hydrocarbon development because it belongs to the public and is subject to appropriation for beneficial use. As to the EMSU itself, then, the evidence for this hearing establishes the following 3 things. The EMSU came to pre-existing commercial produced water in the San Andres, not the other way around. The San Andres is a saline aquifer, not an oil pool, and the San Andres should never have been included in the unitized interval. So let's go through the evidence, the rest of the evidence in the case. What does the evidence establish about communication between Goodnight's disposal interval and the overlying Grayburg Reservoir? First of all, there's no direct evidence of any communication between these 2 separate reservoirs. And the interpreted evidence and opinions that Empire has presented contending there is communication are based on conjecture, speculation, or completely contradict what the direct evidence actually shows. Empire relies on 4 categories of evidence to support their claim about communication. None of them withstand scrutiny. They rely on attempt to demonstrate that there's fractures between the San Andres and Grayburg, that there's water production data supporting the communication, the chemistry data, and the model simulation. I'm going to walk through each one. Okay, fractures first. Dr. Lindsay's original testimony relied on a fracture study in a single well that was limited to the lower Grayburg formation and did not even extend to Goodnight's identified permeability barrier. He testified that he did not even know where Goodnight's permeability barrier was. He prepared an updated fracture study on the same well, the EMSU 679, for his rebuttal, but still did not show any of the interpreted fractures crossed through Empire's permeability barrier. His updated fracture study stopped at 4,180 feet, and Goodnight's confining layer starts at 4,250 feet in the core. That's a gap of more than 70 feet. Now, Empire has presented no direct evidence, therefore, of fractures compromising Goodnight's confining layer. In contrast, the direct evidence from the core, which has been correlated across the unit area and mapped by Goodnight, presented to the Commission, confirms that the measured vertical permeability in the core at Goodnight's barrier establishes, in fact, a geological steal. That is just one of many barriers to vertical fluid migration across an interval of 150 to 200 feet within Goodnight's confining layer. So the effectiveness of that confining layer and the lack of communication through fractures is definitively confirmed by the following. First, the vertical separation in production between the Grayburg and the water management zone, or Goodnight's disposal zone, including the 6 water supply wells that have withdrawn more than 350 million barrels from that zone with no documented oil production. 2, measured and sustained pressure differentials between the Grayburg Reservoir and the San Andres water management zone. That pressure differential could not have been maintained and cannot be maintained across such an extensive area if there was actually vertical communication, as Empire contends. And third, a consistent loss circulation zone below Goodnight's confining layer across the entire EMSU area, as established and confirmed by Empire. 2 main big picture facts alone emphatically prove the effectiveness of Goodnight's confining layer and that the reservoirs are separate and isolated. First, they have different fluid compositions and water chemistry. That's confirmed by Empire's own experts. Second, they have drastically different material balance behaviors, completely different. Now let's get into the water production data. Mr. West from Empire testified in his summary that it is well documented that water is pluming up from the San Andres into the Grayburg, but there's nothing in the literature, papers, or reports to document that. What the literature says is that Edgewater has been encroaching into the EMSU area since the 1930s and has been documented to be encroaching from the west, the southwest, the northeast, southeast, and east, starting with the 1939 Bureau Mine paper that is Goodnight Exhibit cross exhibit 18. And Dr. Lindsay confirmed that Edgewater has been documented at the top of the structure, a 350-foot vertical interval, making it accessible to wells drilled there, depending on what zone they're completed into. So therefore, it's important to understand what, in order to understand water production, you have to understand where the wells are completed and how close they are completed to the oil-water contact. Finally, the MSU is not reporting anomalous water production values on a field-wide basis. Empire is injecting 70,000 barrels of water per day into the Grayburg and producing 70,000 barrels of water per day out. That's the same analysis that Mr. Love gave in 2000 to the division when he said all the water that we are injecting is accounted for except for Edgewater from the Goat Seep. If water truly was pluming up into the Grayburg from the San Andreas, you would expect to see some indication of that in the field-wide water production. Instead, you're seeing that it's balanced, and that does not support the assertion that San Andreas water is pluming up into the Grayburg. Let's talk about the chemistry data. Empire asserts that the chemistry of the Grayburg is changing as a result of San Andreas water mixed with Grayburg disposal fluids pluming up into the Grayburg formation. This water, they say, has higher TDS, chlorides, and sulfate concentrations than the Grayburg water. So if it is truly pluming up, you would see a clear signal in the Grayburg water chemistry. But there is no water chemistry signal at all. Instead, the water chemistry in the wells directly offsetting Goodnight's high rate injection all show concentrations well within the historic field-wide ranges for those constituents, between 16 and 30,000 parts per million for TDS, 7 and 15,000 parts per million for chlorides, and 12 to 2,800 parts per million for sulfate. In Mr. West exhibits I-11 and I-12, he reports even higher historic ranges, up to 60,000 parts per million for TDS, 32 parts per million for chlorides, and 44,000 parts per million for sulfates. Empire's water chemistry simply is not a fingerprint for Goodnight's disposal water at all. It is totally indistinguishable from historic field-wide concentrations. Let's talk about the model simulation now that Empire relies on. Because they had no direct evidence of communication, none, Empire turned to a reservoir model prepared by Dr. Buckwalter to try to bolster their claims. The problem is that the EMSU is so complex and the key data is so sparse or non-existent, especially initial reservoir pressures and early water and oil production data, that the final model is not reliable and demonstrably unable to match real-world field data. These problems are one of the reasons that Goodnight experts recommended not trying to build a model here. That, and there was more than enough compelling direct evidence. Not only was there insufficient key data from Dr. Buckwalter, but the data and input parameters that he did use did not match reality. This was addressed extensively in Goodnight's testimony. He ignored actual data on the complexity of the geology and geological parameters, ignored the locations of actual well completions and perfs, left out dozens of SWD wells and hundreds of millions of barrels of disposal volumes, and ignored or underestimated the influence of Goat Seep Edgewater. All of these problems created a model that is inaccurate, unreliable, and not predictive, and arguably pre-wired to provide a result designed to support Empire's claims that are unsubstantiated by any direct evidence. Here are 4 examples. First, Dr. Buckwalter's model predicts that for every 1 million barrels injected into the San Andreas, the reservoir-wide pressure will increase between 4 to 10 psi, or about 7 psi on average. Goodnight's recent shut-in pressure monitoring test confirmed Dr. Buckwalter's model completely misses the mark. After nearly 40 million barrels of produced water were injected into Goodnight's wells, over about 9 months, the reservoir pressure increased only minimally. Second, Dr. Buckwalter's model predicts that 24,000 barrels of water per day is currently migrating from the San Andreas into the Grayburg. That's about 720,000 barrels per month, or 6.5 million barrels over a 9-month period. With a predicted 6.5 million barrels migrating into the Grayburg from the San Andreas in less than a year, currently, you would expect to see some impact on field-wide water production. But the EMSU is not seeing anomalously high water production values at all. That totally contradicts Empire's contention that the water is actually currently pluming up into the San Andreas and that the model can be considered accurate and reliable. Third, when asked how to explain why EMSU field-wide water production values don't show any impact from Goodnight's injection, as he predicts, Dr. Buckwalter responded that the San Andreas shut-in pressures will show the impact, but they don't. After more than 960 million barrels injected into the San Andreas, Goodnight's shut-in tubing pressures remain on vacuum. In particular, the Piper SWD has injected more than 27 million barrels since 2012, but it shows that as soon as injection pauses for a brief period of time, a month or two, the pressure gradient can return to near initial levels. 0.352 psi per foot at 4,368 feet, as measured in 2025, compared to 0.36 psi per foot at 5,000 feet in the EME H20 in 1959. Goodnight swells show only marginal increases in pressure gradient over time after hundreds of millions of barrels have been injected, contradicting Dr. Buckwalter's prediction. Finally, and most troublesome, the simulation appears to have been designed to make water move up from the San Andreas into the Grayburg, not to address whether there are other more geologically or hydrogeologically reasonable scenarios that could explain the observed water in the EMSU. Dr. Buckwalter initiated his final model with a 35% irreducible water saturation. That had the effect of making water in the Grayburg largely immobile, starving it of water. In combination with ignoring or underestimating the goat seep edge water, lowering the oil water contact, and ignoring well completions and perfs, he dries water up into the San Andreas, ignoring other solutions that better match the data and the literature. In sum, Dr. Buckwalter's model is unreliable, not predictive, and should be disregarded. So what does the evidence show and establish about purported impacts on EMSU operations, actual operations, from alleged changes in water chemistry? First, Empire has shown no water chemistry signal. Instead, the water chemistry shows concentrations completely indistinguishable from historic field-wide levels. Not only does Empire not show a change in the water chemistry, but they also have not shown any actual impacts to their operations or equipment, like increased costs or maintenance. We asked for that in Discovery, we got nothing. What are the impacts? We got zero in Discovery as a result of the alleged change in the water chemistry. Nor could they, for when 40 years, the EMSU has been injecting and mixing known incompatible water from the San Andreas and the Grayburg as part of the water flood. But even if there were somehow some mixing from Goodnight's disposal volumes, Empire has not and cannot show any incremental impact or harm as a result of Goodnight's disposal above the baseline, historic, and ongoing corrosion and scaling issues caused by the long-term and continuing use of incompatible San Andreas water. What does the evidence establish about purported impacts on Empire's planned ROZ operations as a result of the alleged increasing pressure in the San Andreas disposal zone? Well, Dr. Buckwalter claimed that Goodnight's injection will pressurize the San Andreas disposal zone, requiring Empire to purchase at least an additional 10% or more of CO2. But since 1959, more than 960 million barrels have been injected into the San Andreas, resulting in a pressure gradient increase from approximately 0.36 psi per foot in Rice's well to about 0.383 psi, as calculated as an average pressure gradient among 10 of Goodnight's SWDs in April 2025. Disposal simply has not increased San Andreas reservoir pressures, as Empire alleges, and will not require additional volumes of CO2 for an ROZ project as claimed. What about this potential ROZ? Well, Empire presented different cases on petrophysics from two different experts or groups of experts. The first was from NewTek. Empire claims that NewTek provided a high and low case, but really NewTek's witness disavowed the low case and stood behind the original high case that NewTek actually presented. The low case was calibrated to uncorrected core water saturations, which results in significantly overstating the interpreted oil saturations. They picked M&N values based on trial and error. Talk about methods and data. None of that's reliable. It should be excluded. In the high case, the original case that they presented, it was also not calibrated to anything. There were no core oil saturations. The analysis does not honor production tests, mud logs, or other field data. It wasn't even considered. They interpreted oil saturations show conventional mobile oil in intervals that tested 100% water. Again, not reliable. Now, Ops Geologic, they brought Ops Geologic in at the end of this case to try to bolster their claims that there is actually a potential ROZ. Ops Geologic's high and low cases interpret 60 to 80% oil saturations in the EMSU water supply wells, two of them in particular, the EMSU 457 and the 458. The 457 produced 42 million barrels of water and not a drop of oil or skim oil has been reported. The 458 produced nearly 50 million barrels of water and also not a drop of oil or skim oil. The MSU's 6 water supply wells at the very top of the San Andreas structure have produced more than 350 million barrels of water and no reported oil or skim oil. That's all in the OCD division records. There's lines of zeros for every month and every year reported. Petrophysical analysis is not reasonable or reliable just based on this alone. Ops Geologic's interpreted oil saturation profiles across Goodnight's disposal zone also do not come close to the oil saturation profiles of the only known analog commercial ROZ in the tall cotton field. Ops Geologic's interpreted oil saturation profiles, while unreasonably optimistic, are still intermittent and sparse across Goodnight's disposal zone, unlike a true commercial ROZ saturation profile depicted in the tall cotton field, and much more like what Dr. Davidson has identified as abandoned migratory pathways. Now, in contrast, NSAI honored the well test data, the mud logs, and production data in its analyses. Ops Geologic says that it did, but on multiple occasions, their petrophysical interpretations conflict with mud logs, well tests, or the actual production data on the well. NSAI also honored the core data, and contrary to Empire's claims, all rock facies types were available in NSA's petrophysical model, with the exception of the wax stones, which were excluded. Ops Geologic says they calibrated to the core, but their oil saturations in their low case is more than 100% higher than the actual core values. Ops Geologic also excluded substantial volumes of core data reflecting the high end values due to what they call extremely suspicious saturations. This approach ignores actual direct evidence in order to arrive at an overly optimistic interpretation and calculated oil saturations. In contrast, the accuracy and reliability of NSAI's petrophysical model was confirmed in multiple tests, blind tests, against wells in offsetting regional fields, including the SSAU 4113R, the Maljamar 358, and the NMGSAU 522. Every one of those wells confirmed without any modification Dr. Davidson's analysis was accurate, reasonable, and reliable. The bottom line on the claimed ROZ is that there is one ROZ directly below and associated with the Grayburg producing oil reservoir in the EMSU. There's a continuous oil saturations above 20% are potentially an ROZ interval, as defined by Dr. Trentham and Mr. Melzer. Oil saturations below 20% are not economically viable. It has never been attempted. The 679 core data supports the potential for an ROZ down to minus 652 feet subsea and not below that depth anywhere. But even assuming that there is some potential ROZ that could be produced in Goodnight's disposal zone, what's the evidence established about Empire's projected ROZ economics? Using NSAI's average oil saturation for the top 400 feet of Goodnight's San Andreas disposal zone and making only minor adjustments to Empire's economic models to correct unsubstantiated assumptions, Mr. Macbeth showed how the project economics go completely negative. No changes were made or even attempted to address OPEX or CAPEX costs. But beyond the unjustified pricing assumptions, the model is inherently flawed from the get-go. Empire assumes 400 net feet with 30% oil saturation consistently across all patterns in the economic analysis. But Mr. McShane, Empire's witness, testified that none of the interpreted logs in his testimony calculated out to 400 net feet with 30% oil saturation. So Empire's economic model at the start do not match their experts' own analyses and are grossly overly optimistic on the thickness of the ROZ and its average oil saturation. Finally, and perhaps most importantly, Empire's dimensionless curves for the oil and CO2 recovery. Those are really important here, which drive the projected economics because they drive the oil recovery, are completely unsupported by any evidence or data. Empire's dimensionless curve projects an 18% oil recovery after 4 hydrocarbon pore volumes of CO2. That's unreasonably optimistic for an ROZ and not supported by any evidence. Data from conventional Permian fields shows that average oil recovery of 11% after 4 hydrocarbon pore volumes of CO2. Dr. Lake says it will be more like 1/3 of that, or about 3.5% recovery for an ROZ development. And that agrees with Mr. Knight's 1% to 6% recovery, which he developed off the tall cotton field, which would substantially further impair Empire's project economics. Bill Knights showed how, using the recovery factor from tall cotton and Ops Geologic's more reasonable but still vastly optimistic low case, Empire would still need 15-year break-even oil prices of between $200 and $400 per barrel on tighter 10-acre spacing, even than what they're proposing, for their project in the MSU to even approach being economic. Empire also uses a dimensionless CO2 curve showing 95% CO2 recovery after one hydrocarbon pore volume, substantially and unreasonably boosting the project's economics. But this dimensionless curve is from an unknown source and is being used and relied on without any evidence in support. 50 years of actual data shows that average CO2 recovery after one hydrocarbon pore volume is actually about 55%. That is almost half of what Empire is assuming the CO2 recovery would be in its economic model. Using a realistic CO2 recovery factor based on real data will substantially impair Empire's projected economics even further. In short, Empire's economic models quickly go negative by simply adjusting basic commodity pricing assumptions to more reasonable substantiated values, but are guaranteed to be completely torpedoed using real-world oil and CO2 recovery factors. Empire's reliance on an unreasonably inflated oil recovery and CO2 recovery that returns 95% of injected CO2 is just plain unjustified. Using a CO2 recovery factor of 95% just simply, it almost cuts in half the most expensive element of the RZ project, the cost of CO2. Incorporating instead a realistic oil recovery factor based on actual field data and derived from an actual commercial ROZ at the Tallgrass suggests that the actual recovery factor for the EMSU will be more close to about 1 to 6% on the high end, and maybe about 3.5% according to Dr. Lake. And even using a mean value for CO2 recovery of about 55%, based on 50 years of actual data, would almost double Empire's projected CO2 purchase volumes. Now, updating Empire's economic model with actual data-backed oil and CO2 recovery factors confirms that Empire's proposed RZ project will never be economic under any definition. Now, why should the Commission adopt Goodnight's worldview on all this? Its experts are aligned, and the facts and opinions are consistent across disciplines and multiple independent analyses. They all independently came to the same conclusions on all the major evidentiary issues. Unlike Empire, we did not restrain or constrict our experts in any way. We allowed them free range to go and search, find out whatever they could to identify the support of their positions. As you heard in testimony from Mr. Melzer, Dr. Trentham, they were not provided any information other than the core to review. They didn't know about the water supply wells, the depths. They had no detailed information whatsoever to support their conclusions or analyses in their testimony. So what did Goodnight's experts review and agree on? First is the confining layer that separates the two reservoir systems. Multiple data sets confirm a pressure differential between the two different reservoirs in the Grayburg production zone and the San Andreas disposal zone that are separated by a barrier. Mr. McGuire discussed the drilling experience of Goodnight and Rice while drilling the saltwater disposal wells in the EMSU. No losses were occurred in the Grayburg, while major losses occurred in the San Andreas disposal zone, and all experts agree with this observation. Mr. McGuire, Mr. Knights, and Mr. Macbeth all discussed different data sets that showed a measurable pressure difference between these two reservoirs. Mr. Knights took a more holistic view when looking at the difference in how these two reservoirs behave. He discussed how the Grayburg oil reservoir produced hundreds of millions of barrels of fluid, hundreds of millions, from 400 wells, and depleted and lost productivity to a point where the Grayburg needed water injection in order to maintain performance. In contrast, while all that was happening right above, the San Andreas was able to produce hundreds of millions of barrels of water over decades, never deplete, showing that these are two absolutely isolated separate reservoirs, just based on basic geology and engineering principles. Second is the geology of the confining zone. Goodnight and NSAI all agree that there is a clear perm barrier shown in the 679 core. Multiple experts reviewed and corroborated the log characteristics of the perm barrier. Goodnight and NSAI used different techniques to define the perm barrier and ultimately came to the same conclusion over what defines the permeability barrier on a log with similar porosity cutoffs. Dr. Davidson's petrophysical models for lithologies associated with the perm barrier confirmed Mr. McGuire's statements on the permeability barrier from literature review. Goodnight used this agreed upon barrier definition and mapped the confining layer across the field. Dr. Davidson confirmed the correlative perm barrier and spot check correlations. And Mr. Tomastik also confirmed that there must be isolation between the two reservoirs using chemistry by confirming that the native water chemistry of the St. Andrews and Grayburg are very different, proving isolation. The third item that Goodnight's experts are all aligned on is whether there is an ROZ. Many of Goodnight's experts did an independent analysis of where the base of the purported ROZ is and came to the same conclusion. Mr. McGuire placed the base of the ROZ in the EMSU 679 at minus 652 sub C. Dr. Davidson and Mr. Knights using petrophysics showed this base of the ROZ occurring between approximately minus 660 feet sub C and minus 415 feet sub C. Mr. McGuire and Mr. Knights using well tests also confirmed that there is no evidence that the disposal interval is a potential ROZ, while lower Grayburg directly below the oil water contact shows an indication of being a potential for an ROZ. Fourth, the economics of the proposed ROZ in the disposal zone. Mr. Macbeth, using NSAI's oil saturation model, showed that the alleged ROZ is nowhere near being considered economic. Dr. Lake confirmed this economic analysis by showing the dimensionless curve and recovery factors used by Empire are unrealistically optimistic and artificially pump up their economics. Finally, Dr. Davidson and Mr. Knight showed that the original oil in place in the St. Andrews disposal zone is grossly overstated by Empire in an attempt to show a potential commercial project. Goodnight's experts and their opinions are all aligned on each major evidentiary issue, while Empire's witnesses often told conflicting stories, didn't align with the data, or didn't have the data to support their conclusions. What is Empire's true motivation here? With the preponderance of the evidence so clearly showing that there is no ROZ in the disposal zone and that there's no impact or impairment to Empire's operations, Empire has no intent to pursue an ROZ in Goodnight's disposal zone. Every indication is that Empire is not serious about this plan. Their main witness, Mr. William West, devoted 2 paragraphs in his testimony to explaining how they plan to set up their ROZ and a mere sketch of an economic model. The division already gave Empire an additional time to assess the prospects for additional hydrocarbon recovery and directed them to provide monthly reports to the OCD and the State Land Office on their project. You would think that they would want to report to the State Land Office, who owns 58% of the minerals in the EMSU, all the work they were doing to make real their vision. But they have not done that. They're not serious. It's just not feasible or practical to do, nor does it make any economic sense, especially for a company that is struggling financially like Empire. So what's behind all this is that Empire realized that they purchased at least $72 million in plugging and environmental liability at the EMSU, EMSUB, and AGU for $17 million. Not only is Empire in a hole because of the massive liability they purchased, but they're operating with more than $8.9 million in negative working capital, and their status as a going concern remains uncertain because of their operations in North Dakota and Texas have cost more than they expected and have not performed as they'd hoped. Empire is suddenly in a huge hole and they're starting to look for scapegoats. The first was Goodnight, probably because Goodnight is the largest commercial disposal operator in the field. So what Empire is doing now is seeking to devise a legal plan to bail themselves out of this financial hole by attacking the regulatory framework and Goodnight's permits in an effort to use the commission and courts to extract value from Goodnight and other disposal operators who obtained valid permits issued to them under the proper authority of the division. This is not speculation about Empire's intent. It's already happened. Goodnight's been sued, as well as Rice, Permian, Line Service, and Pilot in district court. Mr. Wheeler with Empire confirmed on the stand here in this case that Empire plans to sue every disposal operator who they think are impacting their units within about 2 miles. In a press release issued just last week with its first quarter results, Empire stated, quote, following
We object. More information, not evidence. This is not a summation of evidence in the record. This is Mr. Rankin going apparently through the internet last week. Not an evidence, not appropriate. Nobody's been examined on it. Nobody's sworn to the authenticity. Completely inappropriate for closing argument, and Mr. Rankin knows that.
Mr. Rankin, yeah, I don't want you to rely. Okay.
We'll withdraw it.
Take it down.
Take it down. Thank you. So this is why we're really here. Empire is using the commission as part of its legal strategy to extract value from third parties who are conducting legally valid disposal operations that have no impact on Empire's assets and who are acting under the authority of valid permits issued by the division under the laws of the state. Empire has no actual plan to develop an ROZ in the disposal interval. Empire's plan is simply litigation. Despite having no plan or proof of an actual ROZ, Empire is seeking damages from Goodnight and others for a non-existent, non-recoverable resource that can never be reasonably, practically, or economically developed. Now, Empire claims they suspended their operations in September 2023 because that's when they just discovered Goodnight's injection. But that's nonsense. Their current CEO and president, Michael Morissette, knew about it starting in at least September 2021 when Empire protested the Piazza administrative application. There's no technical or practical reason why Empire could not conduct test operations for a potential ROZ anytime after they acquired the EMSU or the AGU starting in March of 2021. Goodnight doesn't have a disposal well within miles of the AGU. It's folly to suggest that Empire suspended its operations in the AGU because of Goodnight's operations. But remember, they don't have an actual plan to develop that ROZ. The commission should recognize Empire's strategy here for what it is, a ploy without substance or merit. But Empire's ploy is not the reason the commission should rule in favor of Goodnight in these cases. The commission should deny Empire's applications to revoke Goodnight's injection authority because Empire has not met its evidentiary burden on any claim under any of the applications in which they are the moving party. We'll address this and all the other legal issues in more detail in the findings of fact and conclusions of law in the legal briefing. But in short, Empire has failed to prove existing disposal is, right now, causing waste by reducing or tending to reduce the economic recovery of oil, causing any impairment to correlative rights, drowning out by water any stratum capable of producing oil or gas in paying quantities, or causing the premature and irregular encroachment of water or any other kind of water encroachment that reduces or tends to reduce the economic recovery of oil. In contrast, Goodnight has met its evidentiary burden to show injection is not doing any of those things. As confirmed by the division's notice of dismissal with the agreed Cap 10 monitoring program in place, Goodnight's injection addresses the division's obligations to EPA and will be protective of underground sources of drinking water. All 5 of Goodnight's applications for new disposal wells, therefore, should be approved, including the Piazza well, pending de novo review before the commission. And the commission should approve Goodnight's application to increase the injection rate of its Andre Dawson well. Finally, the commission should amend the EMSU unitized interval and special pool that governs the EMSU to remove Goodnight's disposal interval defined as the top of the stratigraphic equivalent of the confining layer identified in Goodnight's structure map and cross sections down to the base of the San Andres. This would just be codifying in an order what should have been done from the creation of the EMSU at the beginning, and what has been the de facto operational arrangement since the EMSU was approved by the Commission in 1984. A producing reservoir overlying a vast and laterally extensive non-productive aquifer.
Mr. Hearing Officer, I have another objection. All of this about what should be done on the EMSU unit, that is a completely different proceeding that may someday proceed and it will involve completely different evidence. And it is legally and procedurally stayed right now. Why council would be suggesting that this OCC has a matter before it to mess with the properly designated oil pool unit in EMSU. This is utterly irrelevant. This is not what's before the commission, and it's in fact legally stayed right now.
All right. Well, I think we can rely on Mr. Chandler to advise the commission of whether or not the stuff is relevant or not. But go ahead, Mr. Rankin.
I'd like to just respond briefly. There is a motion for summary judgment that's been filed and it has been stayed pending the merits of this case. So there is actually a legal move. We have moved to actually do this in these proceedings.
Well, the question is it in these proceedings or is it in some other proceeding that this is tangentially related to?
I understand. We filed the summary judgment motion immediately preceding the commencement of this hearing, and the commission ruled that it would be stayed pending the outcome of this merits hearing. So Mr. Shanley can address it. Yeah.
All right, is that motion filed in any of the case numbers that we're here about in these consolidated cases?
Yes, it is.
All right.
And then, yes.
Okay, then overruled. Please proceed.
As I was saying, this would be just codifying in order, in an order, what should have been done from the creation of the EMSU at the outset, and what has been the de facto operational arrangement since the EMSU was approved by the Commission in 1984. A producing reservoir overlying a vast and laterally extensive non-productive aquifer below, separated by an effective confining layer, with enhanced oil recovery in the oil reservoir above, and produced water disposal and water withdrawal occurring in the aquifer below. That's what's been happening for over 50 years. Here's what we're asking for: that Empire's applications should be denied, Goodnight's applications should be approved, the EMSU unitized interval and special pool should be amended to exclude Goodnight's disposal zone. Mr. Hearing Officer, Chair, and Commission members, we appreciate your attention to this case and all the details and the testimony and arguments of counsel. I want to just make the point that, as in closing, that the Commission always retains jurisdiction over these matters. And if at any time in the future, Empire is able to put forward actual evidence, they can always do so. And the Commission should not be afraid or be concerned about any ruling against Empire here foreclosing or precluding them from bringing forward evidence in the future. The point is that today they haven't yet done so. And until they do, Empire should not be allowed to terminate Goodnight's operations, and Goodnight should be allowed to go about its business with the approval of its additional disposal operations. We appreciate your time and consideration and are grateful for the opportunity. Thank you.
All right, thank you very much, Mr. Rankin. Appreciate it. Mr. Waymeyer, you reserved, I think, 15 minutes for rebuttal. Is that correct?
I think procedurally, I might suggest we check with the other parties. I don't know if they have argument or not, but I would guess they get to go before me. I'm happy to go ahead, but I would have assumed that.
I guess I really don't care. I mean, you want to rebut what Mr. Rankin said, or you want to rebut what everybody says?
I'll hold to rebut what everybody says.
All right, fine. Then, Mr. Beck, I'll turn it over to you for Rice.
Question. Sounds to me that you're trying to utilize the commission to more or less right some wrongs that Empire should have probably known better. Answer. Yes, sir. The commission isn't here to right an awful business decision that Empire made. Its responsibility and its jurisdiction are to prevent waste and protect correlative rights based on facts developed in this hearing for applications to the OCD that are here before the commission. Empire has not met its burden to prove that any of Goodnight's injection operations caused waste, or that revoking their permits would in any way protect correlative rights. Empire's VP of Land and Legal, Jack Wheeler, knows that. And that's why he let slip in questioning with Dr. Mpoma exactly what Empire is improperly asking the commission to do. What he answered when he was asked if Empire is trying to utilize the commission to more or less right some wrongs is yes, sir. When I've done this, and I've probably done 600 to 700 acquisitions in my career, and every single time, my approach to the due diligence was significantly different than what I've been able to determine that Empire did back in 2021. Mr. Chair, Commissioners, Hearing Officer, Counsel, Thank you all for your time and work on this. On behalf of Rice and Permian, I want to thank you for the work that you've done and the work that has to come. Empire became aware of the $56 million in plugging liability in August of 2023, when Empire was responding to Goodnight's subpoena for this matter, and when it got a notice of compliance from the State Land Office. In 2023, Empire came to recognize that the property that it bought for $17.8 million came along with well over $70 million in liability. Let's talk about what we're here for the commission to decide. Waste and protecting correlative rights. It's important to recognize what is the commission's duty in this hearing. This is the July 2nd order on the scope of the hearing. It was amended, and what the jury instructions, as Mr. Chandler said, for this commission are written in this paragraph. Whether granting the application by Goodnight would, applications by Goodnight would, 1, impair correlative rights or cause waste pursuant to section 7-2-11. Continuing on, whether granting the applications by Empire would prevent the impairment of correlative rights or waste pursuant to section 70-2-11. Now, waste is defined in 70-2-3. What it says is waste includes underground waste, as those words are generally understood in the oil and gas business. Whether it reduces or tends to reduce the total quantity of crude petroleum oil or natural gas ultimately recovered. So that means recovered in the oil and gas business. To prove waste, Empire has the burden to prove that there is oil and gas that would ultimately be economically recovered. The New Mexico Supreme Court in 1962 and Continental Oil Company against the Oil Conservation Commission laid out what preventing waste and protecting correlative rights means where the rubber hits the road. Pointed out that our legislature defined these terms. Summarizing, it consists merely of 1, an opportunity to produce, only insofar as it is practical, of actual, in this case, oil, in the pool. The Supreme Court said to state that problem in a different way, the commission must determine, from a practical standpoint, that there is a certain amount of oil here in the acreage. It contains a certain amount of oil. An Empire must prove that there is a determined amount of oil that could be produced and obtained. Now, Empire is not before the commission here applying to produce hydrocarbons from the alleged ROZ. As Mr. Wheeler testified, it's not allowed to do tertiary recovery right now. Empire would have to apply to the commission to do that and be granted approval. Empire has not done that. Why? It estimates that it would be 10 years. Because as this commission saw, Empire does not have the evidence to show that there is an ROZ or that it can produce in the oil and gas business any hydrocarbons from that ROZ. Waste does not equal potential ROZ that is potentially recoverable. Now, Mr. Waymeyer said to you, and I wrote it down, that Empire could meet its burden by proving, quote, any one of these things. That one, there is an ROZ in the Grayburg, or two, there is an ROZ in the San Andres, or three, that there is communication with the Grayburg. That is not accurate. Empire has to meet every one of those to produce to meet its burden to prove that there is waste, or to prove that Goodnight's injection is impairing correlative rights. To find waste, the commission must find that not only hydrocarbons exist, that there is an ROZ, but they must find that they, quote, could be produced. A potential ROZ does not suffice. It must find an actual ROZ that could be produced. Now, there's been no evidence that hydrocarbons anywhere in the disposal zone exist, let alone that they can be produced by Empire. Empire is the only one. Empire is the only one who ordered Empire to stop doing anything in relation to the IMSU. This is from Mr. Wheeler's testimony. Asked the question, yesterday you said you were ordered to stop doing anything with the EMSU, right? Answer, yes, sir. Question, you got sort of ahead of me there. But I was going to say that order came from Empire, not from anyone else outside of Empire, right? That's correct. And you've adhered to that. You haven't done anything else with the EMSU in terms of further development here, right? Yes, sir. You haven't taken any cores of any wells? No, sir. You haven't taken any mud logs of any wells? No, sir. You haven't taken any logs of any wells? No, sir. You haven't drilled any new wells in the San Andres to test for oil? But even Empire bucked that trend. When after this hearing started in February, March of 2025 this year, they applied for permits to drill 3 new wells to prove the ROZ. Filed those applications in February or March of this year. There is nothing impairing Empire from going and testing to prove up the alleged ROZ. So the question the commission must answer is whether Goodnight's operation are producing waste or impairing correlative rights right now, which Empire hasn't proved. There's no evidence, no direct evidence of communication from the disposal zone. There's been a lot of discussion on the San Andres pick for the top of the San Andres. As you just heard discussions, it's been made clear the commission is not deciding here whether the San Andres was properly made part of the unit originally. There's been a lot of discussion of how no one has seen injection into a unit before. That's because the definition of a unit is that the zone must have been produced before, and there's no evidence the San Andres was produced before on the EMSU. The inquiry the commission is making is whether Goodnight's disposal is impairing Empire's production. There's no evidence. Dr. Davidson, you heard a lot about what Dr. Davidson said about the alleged ROZ. But let's look, as opposed to a soundbite, let's actually look at what Dr. Davidson said. Dr. Davidson said The testimony was that he went in and took the San Andreas interval above the yellow band, calculated the oil saturations in there, and came to the conclusion that the economics may be questionable. But then when questioned on whether or not there was an ROZ that existed all the way down to the Grayberg, Mr. Macbeth said there was an alleged resource for that. Based on the discussions we're having now, it sounds like you're saying that at least there is an ROZ in the upper San Andreas. Dr. Davidson said, I think there very well could be. But again, I have a different opinion. I think they look more like migration pathways. They may or may not be aerially continuous, but I can't say with certainty they're not there. They've seen residual oil in the two wells and cored into that upper San Andreas. And again, if Empire feels strongly about that, go for it. I think they should go for it. But I don't think that the injection operations deep are going to impact it. Now, this was a portion you heard a part of. We've established that there are oil saturations above 20%, as you plotted here. Is that correct? Yes. Then tell the commission why you say that there is no ROZ. I didn't say there's no ROZ in the upper San Andreas. Again, I may have a little difference of opinion there from Trenton and Melzer. When I look at actual ROZs that have been established, I see pretty repeatable profile in saturations for the top of the ROZ to the bottom. And I don't see that nice straight line about 40% in the 679 or the RR Bell data. That doesn't mean it's not an ROZ. It just means it doesn't have a profile that matches what other ROZs have. My contention is that the injection operations that are occurring below this yellow band are not likely to impact it. Now, we looked at the yellow band that he said is the barrier between the injection zone and any communication up with the Grayberg. And asked about this, he said, in my view, that's a region that contains multiple potential vertical permeability barriers in the form of bedded anhydrites. However, the preponderance of the data, when you look at it, it's lost circulation. You look at the injection volumes, you look at the fact that we don't see any direct evidence that major water is moving up that's impacting the Grayberg water flood. In other words, we're not saying what we're producing. We're not saying we're producing way more water than we're injecting, which would imply that there's major communication up. My conclusion is the preponderance of the evidence suggests that the yellow interval is providing reasonable protection between the injection zone and the water flood operations above that yellow highlighted area. Until we see evidence, concrete evidence by way of pressure, or the fact that we're producing more water and we're injecting, I'm pretty comfortable in saying that I think those two zones are isolated from one another. So Dr. Davidson testified that he can't say with any certainty that an ROZ doesn't exist in the upper San Andreas. He did not say that an ROZ existed. He said what he saw was migration pathways, now abandoned from long ago. Injection has been going on for more than 60 years in the San Andreas. An ROZ is not recoverable through ordinary means. That's what it is. It requires CO2. It's not wasted away by injection. Now, the real question here, and the answer is that Dr. Davidson's, Mr. McGuire's separation of the injection zone from the Grayberg and any operations and any alleged ROZ in the upper San Andreas is supported by common sense and operational reality. The question is, how could Empire pressure up the water flood it's doing in the Grayberg when there is a vacuum zone underneath, if there isn't an effective barrier in between? Rice's saltwater disposal wells operate on vacuum only, as they have for only 60 years and as they continue to operate today. If they operated on only vacuum and there was communication pressuring up of the San Andreas into the Grayburg, how could they operate on vacuum? With the evidence here, there is no waste. There's not evidence an ROZ exists, let alone the ROZ could somehow be produced. And this after Empire says it's expended $30 million in this litigation. We've heard a lot about the state land office and that it owns 58 to 59% of the mineral interests. Now you heard from Mr. Wheeler that Empire went to the state land office to get support for this. You heard testimony that he had written support. Of course, that's one of the many things he had to go back and change. He changed that and said, actually, after those discussions with the state land office asking for support, they didn't have it. They didn't have it in written form. They didn't have it in oral form. The only evidence of waste is evidence that supports denying Empire's applications. It's evidence that 60,000 barrels per day of disposal from 13 different oil and gas operators would be stopped if Goodnight's injection is revoked. That evidence weighs in favor of denying Empire's applications. As Mr. McGuire pointed out, despite the misleading evidence and cross-examination, if you look at the actual data for oil and wastewater production, they've gone up significantly since 2023 and continue to go up. Empire did not do its due diligence. It relied on a marketing pamphlet from XTO that represented, not as Mr. Waymeyer told you on his closing argument, an ROZ. It represented a potential ROZ. A potential ROZ of 350 feet where the bottom was negative 700 subsea. Now, when Mr. Wheeler was reviewing the first page, it says under that description, 3 existing units, EMSU, EMSUB, AGU, all have infill drill and well and ROZ potential, right? Yes, sir. What does potential mean to you? Reserve reports, you basically have 3 categories. You've got proven, probable, and possible. So potential would fall into the category between possible and probable. That's what it means to you. Yes, sir. It's not even provable. It's not even probable. It's somewhere between probable and possible. Now, you heard Mr. Waymeyer question Mr. Macbeth about his experience with ExxonMobil and what a great company it is, what a successful producer of oil and gas it is. Now, when I went up and asked Mr. Macbeth that, knowing all he does about ExxonMobil, what a great company it is, what great returns it makes for its shareholders, that after ExxonMobil identified this potential ROZ, it went ahead and sold the properties. Because ExxonMobil recognized that this was not recoverable economically. Now, what should the commission do? Well, the Continental Oil Company gives the commission the answer. The commission should conclude that Empire has not proven that Goodnight's injection is producing waste or impairing correlative rights. Empire hasn't proven that the injection zone contains, quote, a certain amount of oil that could be produced and obtained. Should deny applications to revoke Goodnight's injection permits that were approved by the Oil Conservation Division at a contested hearing. And it should allow Empire to go forward with its 3 applications from March or February to drill to the bottom of the San Andreas, to perform the 3 types of coring for those wells it said it did, and to allow them to bring evidence back before this commission of an ROZ and an ROZ that can be produced. And at that point in time, the commission can decide on whether to allow Empire to go ahead and do that. Thank you.
Thank you, Mr. Beck. Appreciate it. Mr. Suazo, closing remarks for pilot.
Yes, thank you, Mr. Hearing Officer. Good morning, Mr. Chair, Commissioners. Miguel Suazo with Bating Wozniak, appearing on behalf of Pilot. First of all, I'd like to thank you all for the opportunity to present a closing statement today on behalf of Pilot and largely in support of Goodnight's applications. You know, the record developed in this proceeding through weeks of exhaustive testimony, cross-examination, and pages of technical evidence, Pilot thinks points to one conclusion, and that is that Goodnight's operations are consistent with New Mexico law and sound engineering practices. Pilot feels that Empire has failed to meet its burden to justify either revocation of Goodnight's injection permits or denial of its pending applications. And however the commission decides this case, you know, they're well aware, you all are well aware that the industry is watching. And industry is watching because they're concerned about the impact and the reverberations that the decision in this case will have on the EMSU and beyond the EMSU. So, you know, in looking through the record last night, you know, let's start with the core issues, which are waste, correlative rights, and technical viability. You know, throughout this case, we've heard Empire repeatedly claim that Goodnight's injection operations are impairing future recovery from an alleged ROZ in the San Andres and the Grayburg. But time and time again, Empire's own witnesses either failed to quantify the alleged recoverable oil or conceded that their conclusions are speculative or based on outdated or uncalibrated data, or admitted that further data and years of study would be needed to support their vision for the development of this area. And I was looking at Dr. Lindsay, which is, as you know, Empire's central geologic witness. He admitted that he had not evaluated whether the oil in place was technically or economically recoverable. He testified that there's no evidence of lateral communication between the Capitan Reef and the EMSU, and that deeper core samples would be needed to determine whether an ROZ in the San Andres could even support a viable project. And the questioning, especially from Commissioner Ampoma, highlighted the absence of commercial viability and concrete reservoir engineering data. And that was apparent throughout this proceeding. Empire's petrophysical witness, we also believe faltered. Mr. DeWellen admitted that he had never before performed a petrophysical analysis for ROZ development and used log data uncorrected for water saturation, which we think is a critical flaw that undermines Empire's oil saturation claims. And he also acknowledged that he relied entirely on Empire's provided data without calibration because of concerns over cost. Empire's engineers included Mr. Merrick and Mr. West, who could not show that production data to confirm mobility of oil or any measurable interference with operations in the Grayburg. Mr. Merrick, as Mr. Rankin mentioned, relied on NewTek data and admitted that he was not asked to evaluate either reserves or recoverability. And Mr. West also testified as to speculative models for chloride migration, but conceded that there was no per well data pre-1970, and that he had no direct evidence that Goodnight's injection was impairing Empire's operations. And Goodnight's engineering witness, Mr. Macbeth, thoroughly, we think, rebutted Empire's assumptions and showed that Empire saturation claims are inconsistent with 100% water production in the field. Now, I really felt like Commissioner Ampoma's questioning in this case was really instructive and telling, seemingly to me that his core focus was on the core concern of whether there's sufficient evidence to determine that the San Andres contains a commercially viable ROZ that justifies denying Goodnight's applications or revoking its permits. And, you know, throughout this case, I think that witness after witness has failed to provide that evidence. Even Mr. Trentham, Empire's ROZ expert, admitted that his views were based on analogs and not EMSU specific engineering or economic data. He conceded that he had no production cost estimates and based his assumptions on highly generalized recovery factors from unrelated projects. Now, Empire is claiming an imminent threat to recoverable hydrocarbons. We think that's further undermined by Mr. Wheeler's testimony. Mr. Wheeler conceded that Empire did not do meaningful due diligence before acquiring the EMSU, not even a site visit. And I think Mr. Beck, greatly touched on this point. They learned of this massive plugging liability and other burdens, and they're trying to use the commission as a tool to address their lack of due diligence. Empire's entire case, as we see it, hinges on a speculative ROZ recovery scheme for which it has no current regulatory authority, but it could certainly pursue. Empire would need to return to the commission for approval of a tertiary recovery project, conduct more core sampling, develop reservoir models, build CO2 pipelines, source CO2, and they admit that will take many, many years. Goodnight, by contrast, has presented a compelling and well-supported case grounded in regulatory precedent and engineering integrity. Mr. Macbeth and Dr. Davidson, we think, established that the San Andres has long functioned as a non-productive aquifer and disposal zone. And Mr. Davidson is a world-class petrophysicist. He explained that neither the profile nor the data support ROZ classification within the disposal interview. And he also confirmed that isolation exists between Goodnight's disposal zone and the Grayburg, and that therefore no waste or impairment or correlative rights is occurring. So in sum, Pilot believes that Empire's claims are built on hypotheticals, marketing brochures, and Goodnight's case is grounded in the law, field data, sound reservoir engineering, and decades of regulatory precedent. So to grant Empire's applications would set, we think, a dangerous precedent, one where hearsay and speculative future plans outweigh proven compliance, economic necessity, and scientific rigor. So today, Pilot respectfully asks the division to deny Empire's applications to revoke Goodnight's permits, that they approve Goodnight's pending applications, and reaffirm that the San Andres within the EMSU is a valid disposal zone unless and until new data from Empire or others justifies a departure from settled law and practice. The evidence simply doesn't support Empire's requested relief. We feel that Goodnight has met its burden and Empire's not. And it's important that the rule of law, the integrity of the commission's permitting process, and the regulatory certainty upon which New Mexico's oil and gas industry depends demand nothing less. Thank you.
Thank you, Mr. Suazo. All right, Mr. Waymeyer, this is your 15 minutes to rebut not one, but three closing arguments.
Thank you, Mr. Hearing Officer. I'll just take this a little bit in the order that Mr. Rankin raised it. And I think that his organization and what he chose for the substance of his presentation perfectly encapsulates this company, Goodnight, and their dirty tactic. It's truly in their bone marrow. As we start, I gave him too much credit. The statements, the two statements he started with, neither one of those are even sworn. That was something that Mr. Moander drafted. A lawyer drafted that. So ignoring it hasn't been received in evidence. What he chose to lead with was prepared by a lawyer, not a scientist, not somebody with the OCD, a lawyer. With respect to the scope of the hearing, there is an entire hearing order that was issued as part of this case, identifying the scope. In no way, shape, form, or fashion does that scope of the hearing include this commission somehow modifying, changing, reforming the EMSU oil unit. The motion for summary judgment that he spoke of, there's an order from Chairman Rosados that on March 4th, 2025, that denied that motion for summary judgment. With respect to the scope of this hearing, that was clarified in an order also issued as part of the proceedings. And so the slides that he led with, not sworn testimony. In fact, they were created by Mr. Moander. And with respect to the scope of the hearing, you don't have to take my word. Mr. Beck helpfully volunteered in his closing remarks that that is outside the scope of this hearing. It is pending other places that are not here and that are stayed. And we can certainly have that fight. But again, all of the stuff about the EMSU, those arguments are about what he wants to have happen to a unit order that has been unchallenged and unchanged for over 40 years. With respect to the OCD testimony, the settlement that Goodnight cut at the finish line, literally at the finish line before Mr. Getz got up, is exactly what the OCD was asking Goodnight for from day one. They chose to make the deal at the finish line that OCD wanted from the very first day, precisely so that you didn't hear OCD's testimony. The reason you didn't hear those folks is because they cut the deal that OCD wanted from the very start at the finish line to keep you from hearing it. The pressure data, it is, again, if you go back and look at the pressure data, if the rate of injection goes over 1,500, the algorithm in the system immediately sets it to 0. So it appears that there is no injection volumes, even though there are injection pressures. That was an error in the system. This is explained in Mr. Williams' sworn statements. That accords with all of the other data that we've heard about. The idea that they still come back to that in these closing arguments is just, you slap your head. It's only the kind of conduct that a company like Goodnight is capable of. On the pressure, you heard Mr. McGuire talk about the vast drop, the fast and drastic drop of pressure upon sucking the water out as part of the water supply wells. How on earth do you not have that identical rapid increase in pressure as you put it back? And again, Dr. Lake and others have testified to that rapid pressure increase that's being observed. And it was proved by that wire line measurement in the Rhino well at 750 subsea. It's proved by the entire trend of water levels, even if you take it off of their fluid gun readings. With respect to the economic modeling, Mr. Macbeth was asked if you have any critique of what Empire has prepared here, other than the WTI and the CO2 pricing, where is it? He didn't offer any other variation whatsoever. And in fact, the dimensionless curve is a dimensionless curve that Goodnight's own experts have used. Mr. Macbeth confirmed that it was the scope of the work here for the Goodnight experts to merely pick on what Empire done, as opposed to performing ground up analyses here in support of anything that Goodnight could actually come here and with a straight face urge to the commission. This idea about this is an effort to extract value, the OCC doesn't have purse strings. When you issue your order, there's not going to be a damage award on that. This is about stopping the destruction of the natural resources. And that has nothing to do with the district court proceeding whatsoever. That can involve damages. This is no different than what Goodnight said as part of its Texas case that Mr. McGuire was asked about. They literally defended at the Railroad Commission of Texas on the basis that, hey, we've already done all the waste. You can't, Railroad Commission of Texas, stop the Commission of Waste because we've already done it. Let us just go answer in damages over in the district court case. The idea that this is somehow some kind of a ploy or a game, that Empire would spend millions of dollars to prepare this case and bring it for presentation to you all as part of some kind of a damage recovery, is complete nonsense. And if you wanted to indulge that, you would have to believe that William West and all of the other Empire witnesses are just liars. Mr. West took the oath and he sat in the box and credibly told you exactly what the plans are here and what will happen as soon as the saltwater injection stops. They are literally calling Mr. West and the other Empire witnesses liars. While we talk about that, from credibility is absolutely something that the commissioners, as fact finders here, you need to assess. Credibility comes in things like education and credentials, what work actually happened here. But credibility also comes in how do you react to the questions. Empire presented witness after witness after witness that sat in those chairs, listened to your questions, listened to the questions of counsel, and answered precisely the questions that were asked. What did Goodnight offer here? Witness after witness after witness who evaded, wouldn't answer the question. Mr. McGuire thought it was comical. He acknowledged many times, I'm just not going to answer the question. You couldn't get a straight answer out of the Goodnight witnesses, and that absolutely goes to this issue of credibility, which is incredibly important. And we heard all three of the closing arguments here talk about how important this is to oil and gas producers. If this was so important to Rice or Permian or Al, where is their witness? Did you see them bring anybody here to testify to the OCC or to participate in any kind of a meaningful way as part of these proceedings. For that matter, did we see any Goodnight witnesses? Not one single Goodnight witness could be bothered to come all the way to Santa Fe, New Mexico to talk about the harm that they've occasioned on Empire's EMSU and on the state of New Mexico's minerals. Not one single employee of Goodnight could be bothered to come here to Santa Fe to testify. It's a company that just to its bone marrow does not care. I'll address briefly some of Mr. Beck's remarks. I think he's confused. Thankfully, we have Mr. Macbeth's testimony correct, Mr. Beck. The testimony he cited about probables and possibles, PUDs, PDP, those are SEC concepts. There are entire rules under the monographs about how you book SEC reserves and what the SEC lets you testify, lets you report to the public. Mr. Macbeth confirmed SEC reserves have nothing whatsoever to do with this proceeding. I do not want the commissioners to be misled as you talk about quote unquote probables that the SEC lets you book. Completely different concept than the preponderance standards that are applicable to your consideration of the issues here before you. That's just a matter of Mr. Beck not understanding.
Mr. Hearing Officer, I certainly object to that statement, and I think it violates the chair's direction for decorum. And I sat back while Mr. Waymeyer laughed and threw his arms up during Goodnight's closing and during my closing, and I didn't say anything, but I certainly take offense to that statement, and I think it violates the chair's instruction on decorum.
I have a response I'm very happy to make on that.
Your objection, Mr. Beck, is noted, but people get a fair amount of leeway in cross-examination, and if they want to throw barbs at each other, well, I think the commission can take it for what it's worth. But your objection's noted. Go ahead, Mr. Waymeyer.
Again, the idea that Mr. Beck would, in terms of the participation he's contributed to the proceeding, that he would choose to spend time on SEC probable and possible reserve categories with all of the regulations and federal applicability to that, and somehow bring it here, that has anything to do with what's before this commission, is completely laughable. We absolutely agree that what the commission is doing here is vitally important. Absolutely, this is important. If this commission finds by a preponderance that there is an ROZ in the San Andreas, we're done. The saltwater injection must stop. And we've proved that with the testimony of actually Goodnight's witnesses. The testimony we showed you as part of these closing remarks was Goodnight's witnesses agreeing to these issues. Mr. Beck and Mr. Rankin struggled to make their case using the testimony of their own witnesses. We didn't even go into detail into all of the testimony from Mr. McShane and Dr. Lindsay and Dr. Trenum and Mr. Burkhead and Mr. Bailey. Over and over and over again, these witnesses credibly sat in the chairs, listened to your questions, talked about their qualifications, the data they looked at, the methods they employed, and the conclusions that they reasonably came to. And all of those point the exact same direction as the Goodnight witnesses have conceded. There's a ROZ in the San Andreas. The reason it's not being developed is because of Goodnight. And it must stop for that oil to not be wasted and lost. Additionally, we know there's a ROZ in the Grayburg as well. If this commission finds that there is communication and that saltwater injection is leaving into other formations, at that, we're done here too. If the commission finds that by a preponderance of the evidence that the Grayburg is threatened, that is waste. The commission must step in to protect correlative rights at that interval, at that basis. Again, I just will close by saying on behalf of Empire how vitally important we think this case is for the state of New Mexico. They are asking you to set a standard that it is okay to permit in and inject into unitized intervals in violation of Empire's and its predecessors and others' rights in those established by things like Section 10 of the unit agreement. This is not the place. There is no reason whatsoever to set that precedent in New Mexico or for future OCD conduct. And coming back to the water volumes, we were clear. These are Goodnight says it's a Delaware water servicer. The volumes you've seen straight off of the dashboard of Drilling Info Inverse that's the Delaware water off of that dashboard of Inverse. Because they said that if they want to say that there's more saltwater volumes that the commission should consider, guess what that does to the market share of Goodnight? It gets even smaller. The idea that this commission's actions in protecting one 14,000 acre spot in New Mexico is somehow going to have any effect whatsoever outside of those 14,000 acres on any operator, on any SWD operator, is completely unsupported in any of this evidence. Now, if the commission goes the other way and allows trash disposal companies to put salt water into an existing producing oil unit, that's a whole different standard. I do understand at that point why all of the producers that they cite would be watching up here on our Zoom. If the precedent we're going to set is that the OCD and OCC condones injecting into designated productive oil units in New Mexico, I understand why a lot of producers would be pretty concerned about the OCC taking that tack. Again, for my group, I very much thank everyone for their time and attention. We look forward to being helpful with the briefing to come, but anticipate that that's going to be a pretty short process because this injection should have never started. It needed to stop from the get. It needed to stop yesterday. We needed to stop today. Thank you very much.
Thank you, Mr. Waymeyer. All right. Chairman Rosatos, I see it's about 12:45. Do you need to, I think we can, I just wanted to talk with the parties about findings of fact and conclusions of law, but I don't think that'll take long. And I think we can get you out of here in time for a noon lunch hour, if not before. Does that work for you, Mr. Rosatos?
Yes, that's totally fine as long as I can get out of here just a little before 12.
Okay, yeah, the goal is to, I mean, we'll be completely done with this. If we can do that, we'll be completely done with this at that point. All right, and we'll just adjourn the entire proceeding, a concept which at some points in time during this process, I was not necessarily optimistic we would ever reach, but here we are. All right, so folks, let me ask both sides. I'll start with Empire. Findings of fact and conclusions of law. I'm assuming that you'll want X number of days after the full transcript is available. Thoughts, Mr. Waymeyer, or the Empire team? I see Ms. Shaheen coming forward.
He wants you to articulate what you want to say. Is that we have?
Yeah, so we have all of the transcripts except for the last 4 days. So we do not see these transcripts as being caused to delay anything. Again, it's just the last 4 days lacking. It's out of our control on how fast these things come back in. There is video available. So if anybody thinks that something is vitally important, this is all recorded. So they have that. And we have they've been doing a wonderful job, but we have some new stenographers that have come in over the last couple of days. So our concern is just, we don't want this tied to hearing transcripts that could be multiple months away. Just not knowing on when they'd come in. In terms of the concrete timing, I think Ms. Hardy can address that in more detail. But again, we do have great concern because this is happening in our unit as we speak. We need this resolved promptly, that it would be tied to not a firm date on transcripts.
Well, we can tie it from today. I mean, it can be X number of days from today instead of when the transcript is ready, as long as the parties agree.
I think tying it from today is very appropriate and lets everybody know that this is going to be concluded and lets Empire's ownership and management know that we're going to be prompt on getting to a decision here.
Mr. Rankin, your thoughts?
Thank you, Mr. Hearing Officer. We had been discussing, my colleague had been discussing with counsel over with Empire about potential timeframes and other parameters for closing. Empire had suggested that the filings be no later than June 23rd. And that they had suggested 30 pages for findings of fact, conclusions of law, single spaced, and 25 pages for legal briefing, double spaced. That's more than we had proposed, but we're happy to accommodate them and have additional capacity for findings of fact and briefing. We had proposed a little bit longer time frame than they had to complete all the work and review all the records and testimony and evidence. It's substantial, more than the standard that is normal. So I think we're happy to have a firm date. It's fine with us, but June 23rd is a little bit earlier than we would prefer. So we would ask that that we set a deadline of July 3rd before the holiday for a deadline to file the findings of fact, conclusions of law, and the legal briefing. And then I think we'd also discussed having an opportunity for a response on the legal briefs. We had discussed 10 days under the rules. They had proposed 10 calendar days. It was a little bit tight. So we would ask for 10 days under the rules, which would not include the weekends, in order to file a response to any legal briefing with, I think we had agreed no reply briefs. Is that right? Is that right, Dana? No reply briefs. So 10 days, our proposal would be 10 days, not including weekends, following the legal brief for a response.
And Mr. Examiner?
Yes.
We did talk with Mr. Rankin and Mr. Jurgensen, and I wanted to give you our proposed dates because we can modify them somewhat from what we had initially proposed to them. I think it's our position that, as Mr. Waymeyer said, we don't need hearing transcripts for the legal briefs. So we would propose to file those 30 days from today or no later than June 23rd. Since we already have several of the transcripts and we don't necessarily need them for the legal briefs. And then regarding findings and conclusions, we would propose to submit those 15 days after the final hearing transcript is available. So we would propose to separate between the legal brief and the findings and conclusions.
Okay, before we further discuss this, Chairman Rosados is trying to get out of here to make a lunch meeting, I think. Chairman Rosados, unless you think you actually need to hear all these details, we could fill you in on what ends up being agreed to. If you'd like to take off now, it's of course up to you, but wanted to give you that opportunity, and also an opportunity if you had closing remarks to make at the conclusion of this whole hearing, whether you wish to make those now.
Thank you, Mr. Hearing Officer. I will take you up on me potentially leaving. I don't have any closing remarks. And if you could just fill me in, I would appreciate it. I apologize that I do need to leave. I'm sorry, I didn't know where we were going to be at. But I thank everybody for their patience and diligence in trying to make everything work as smoothly as possible. And Mr. Hearing Officer, I'll just wait to have you fill me in on these end details.
Okay, thank you, Chairman Rosados. All right, I appreciate that.
Thank you.
Then okay, so getting back, okay, so what I heard from you, Ms. Hardy, is your proposal is briefs by June the 23rd of 25 and Findings of fact and conclusions of law. I didn't write that down, but it was a time frame tied to the briefing.
Mr. Examiner, actually, I've clarified with Empire, and we would propose that both documents do be filed at the same time, or that the deadline be the same, because I think it makes sense for the commission to look at them together. So we would propose the findings of fact, conclusions of law, and the brief due either 14 days after the final hearing transcript is uploaded to the case file, but in any event, no later than June 23rd. Because we do want to have this decided.
I don't want to get into language that ends up being a contractual issue. Let's pick a date either from today or from when the transcripts are ready and filed, but let's not have an either or.
Then we would just propose June 23rd for both.
June 23rd and Goodnight wants an extra week. I tell you what, I'm gonna err on the side of giving everybody an extra week. That way, if there is any hold up or delay in the transcript, it's more likely to be available and not become an issue. So how about
I'm sorry, Mr. Harwood. This is Trevor, the reporter. I figured it might be a little helpful. Our estimated transcript turnaround date for today's part of the transcript would be June 5th, 2025. That's helpful to you at all.
It is helpful. Does that help the parties?
I think so, Mr. Examiner, and I think that would definitely make the June 23rd date work.
All right. Well, I'm going to give Mr. Rankin the extra week. I mean, a week's not going to matter one way or the other, I don't think, to either side, given the length that this proceeding has taken already. So am I hearing then that everybody would agree to their initial briefs and their findings and conclusions by July the 3rd of 2025?
What's the matter with June 30th?
That's acceptable to Goodnight.
It's fine with Rice and Permian.
I think
That
that's
works
fine.
for Pilot.
I'm sorry. Okay, did I hear Mr. Suazo say yes?
Yes.
All right. And then my understanding then is that everybody agrees to response briefs within 10 days after July the 3rd, the 10 days not to count the weekends.
And we had proposed that we do count the weekends, Mr. Examiner. We had proposed 10 calendar days and they had proposed 10 business days. So that's the difference. And again, we would just like to have this matter decided as quickly as possible.
I understand, but we'll follow the civil procedure rule on that. I think it's anything under 11 days. You don't count the weekends. So we'll go with Goodnight's request on that. So 10 days for response briefs after July the 3rd, not counting weekends or holidays if there are any.
It's July 17th.
Okay, which I guess if let's clear this up now, since deadline for briefing is July the 3rd, so don't count the 4th.
July 18th.
So July 18th would be the deadline for response briefs.
I'm terrible at arithmetic, but I'll take your word for it. All right. Now, was there discussion about page links on findings and conclusions and or briefs?
Yeah, we had discussed that and had proposed and are willing to accommodate Empire's proposal. I think 25 pages, single space for findings of fact and conclusions, and 20 pages, Dana, for the legal briefs.
We had 25 pages for legal briefs and 30 pages for findings of fact and conclusions of law.
Yeah.
Single spaced on the findings and conclusions,
Yeah,
which
that's
is typical for the commission, the division.
That's acceptable to Goodnight. Do we want to put a limit on response briefs with the 10 pages for response briefs?
That's
Yeah.
fine.
Okay.
Okay, so 30 pages on findings and conclusions? Did I hear that right?
Yes.
And 25, a single space and 25 pages on briefs, the usual double spacing,
Correct.
and 10 pages on response briefs.
Correct.
Okay, that's all of record. Rice and Pilot, are you guys on board with that?
It's fine with Rice.
That's fine with Pilot.
All right, Dr. Ampoma, any questions?
I'm sorry, this is the reporter. I was thinking that the attorney for Rice and Pilot was both Mr. Suazo. Who's the one who answered just before Mr. Suazo? Sorry for this.
That's Matthew Beck, B-E-C-K.
Thank you. Sorry, just getting mixed up a little bit. Sorry for the interruption.
That was just a joke, Dr. Ampoma. You don't have to ask any questions of these guys. I don't need to. I probably don't need to keep you gentlemen here for all of this. Come to think of it, but you're.
Rev, I had one quick question. I was asking if we can get the presentations from the conclusions that was presented today.
And also, I don't know who was just talking. Can I find out who was just talking?
Yes,
Dr. William Ampoma.
Gotcha. Thank you.
Okay.
For the part of Empire, we would very much appreciate the opportunity to provide you with the closing slide presentation. And I misspoke. One of them was a Mr. Burkhead slide that I spoke in percentages as opposed to millions of barrels in oil per place in section. So I'm glad you'll get that to have that correction at the bottom, not a percentage.
All right. Do you have any objection, Mr. Rankin, to both sides? I guess everyone's Rice and Pilot. I guess Pilot didn't present any documentary backup during closing, but is everybody agreeable that what they reference during closing be made available to the commission?
That's agreeable, and I will exclude the reference to the press release that Empire had submitted for media